Item number 37. Here, Lordship, I am awaiting instruction, Lordship. Let it be come up on 24/7. I have taken the consent. Petitioner in person is 24/7 date may be fixed, Lord.
Oh, then the petitioner.
Yes, petitioner in person. Therefore, Lordship, I have taken the consent to fix the matter on 24/7. Oblige, your Lordship. Oblige.
May I please, your lordship? My lord, I am sorry for making an unusual prayer, my lord, regarding supplementary motion item 54, my lord. My lord, matter relates to eviction, my lord. Eviction process has already been started today at 10, my lord. My lord, may I pray that this matter may be taken up as a first motion item, my lord? My lord.
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 45, lordship. Lordship, kindly allow 3 weeks time to file a affidavit, lordship, after vacation, lordship.
What's the time?
Income tax department.
Income tax. Then the general.
Oblige.
May I please? May I please? A bit mention listing है motion matter मेरा day after tomorrow my lord.
Sorry,
Motion matter मेरा day after tomorrow my lord listing.
motion matter.
My
Have you filed it?
Yes, lord. I file. I've got serial number, my
If you filed it,
lord. It is very urgency, my lord.
file quoted. Right? No, it will come.
No, my lord, it is very urgency, my lord.
What is the urgent?
Relate to election of property sources, my lord. Date of election 27, my lord.
All right, day after.
All right.
May it please, your lord. My lord, with the consent of the other side, my lord, I beg to mention item number 42, 43, and 44, my lord.
Right.
Now, similar matters are fixed on 22nd of July regarding
Wait,
first
wait,
measure,
let the matter come up.
my lord.
May I please-
Unnecessary matter.
may I please- I beg to mention item 39 and 40. In this case, Lordship, affidavit in opposition filed by a respondent and one who wants some time to file a reply on it. 39 and 40.
39 and 40.
40.
The
I have-
request of counsel for the petitioner and the judge for 4 weeks.
Oblige, Lordship.
May I please, your lordship, I beg to mention item number 33. Lordship, allow us 3 weeks time to file our affidavit.
You wait until the matter is called up.
Okay, lordship. Highly
Yeah.
obliged.
May it please, your lordship. I beg to mention item number 1, 2, 3, your lordship. Actually, these are old matters, lordship, and on behalf of Mr. P.N. Goswami, lordship, he is under bereavement, lordship. I am praying for adjournment of this matter.
Wait for the term. Item 1, 2, and 3 will come just now.
Lordship.
Yes, please, your lordship, I beg to mention item 17 with the consent of the other party,
70
17, lordship.
17.
We need some more time to file our affidavit. I'm on behalf of respondent number 1.
Have you who's for the petitioner?
Yes, we have taken the consent of,
You have taken consent.
yes, sir.
4 weeks. 17.
Obliged, lordship.
May I please, your lordship, I beg to mention that item number 25, my lord. Matter may be passed over for the day. My indiscretion due to some personal difficulties.
25 passport. Be listed after beginning.
May it please, my lord. With due consent of the other side, I beg to mention item number 46 of the daily list, my lord. Instructions are awaited in this matter, my lord.
You wait for the term. Wait for you.
Your lordship, I beg to mention for listing of a WBC matter, it's a transfer matter, lordship.
Transfer.
Transfer
This
matter.
is not the bench for transfer.
Lordship,
You mentioned before appropriate bench.
obliged, lordship. May I please, your lordship, I beg to mention for listing for orders, lordship,
What matter? What is the
non-payment,
subject matter?
non-payment. lordship.
Non-payment. You'll have to come after vacation. After vacation,
Lordship, the reopening date, lordship.
not reopening. 1 or 2 days after that, 19th July. 19 July.
19th, lordship, there is so urgent, lordship.
How many years your bills have not been paid?
5 months.
5 months. Let it be on 19th July. We'll try to dispose it of.
Obliged.
Yes.
May I please, your lordship? My lord, in this petition, we have challenged a notice of eviction. My lord, may be pleased to find that notice, my lord, is at page 29.
Yes.
My lord, may kindly note the date. It is of 12/6/2024 to all the inhabitant of Jagirud Railway Quarry siding area, Morigaon, Assam. No person's name has been, my lord, had been included. It is a, my lord, blanket application of this notice. Now, as a result, my lord, the petitioners, herein only 10 has approached before my lord, and along with, my lord, 1,500 families are residing therein. Now, my lord, today morning at 10 a.m., my lord, the notice has been issued on 12/6/2024. My lord, may kindly note that in this notice, my lord, in this connection, proceeding against unauthorized encroachers as per the Public Premises Eviction Act 1971 has already been completed. But my lord, no procedure under the PP Act, my lord, had been initiated or completed, and this is not correct, my lord. My lord, if you go by the Public Premise Eviction Act 1971, my lord, I have brought 2 copies, my lord. My lord, I have bring a printout copy.
Yes.
Now, my lord, section, I would like to draw my lordship's kind attention, my lord, to section 3, my lord.
3.
3, my lord. Appointment of state officers. Because the notice can only be issued by the, my lord, a designated state officer. Appointment, the central government may by notification in the official gazette appoint such person being gazetted officer of the government or of the government of any union, temporary, or the officers of the equivalent rank of the state statutory authority as it thinks fit to be the state officer for the purpose of this act, provided that no officer of the secretariat joins from job. So therefore, my lord, there is a requirement of appointment of the state officer. Now, if we go by the impure notice, my lord, that this person has not yet been appointed as a state officer, my lord, and he has been signed this notice. My lord, may kindly see the senior divisional engineer 1 NF Railway Landing. And secondly, my lord, the requirement of the PPE Act, if my lord may go by the provisions of section 4, my lord, issue of notice to show cause against the order of eviction. Now, my lord, if the state officer has information that any person is in unauthorized occupation of any public premises and that he should be evicted, the state officer shall issue in the manner hereinafter provided a notice in writing within 7 working days from the date of receipt of the information regarding the unauthorized occupation, calling upon the person concerned to show cause why an order of eviction should not be made. If the state officer knows or has a reason to believe that any person is in unauthorized occupation of the public premises, then without prejudice to the provision of subsection 1, he shall forthwith issue a notice in writing calling upon the person concerned to show cause why an order of eviction should not be made. Now, my lord, these are the mandatory requirement of the PPE Act. Nothing has been followed, my lord. Directly, this impure notice has been issued. Now, my lord, section 5 is also relevant. Eviction of unauthorized occupants. If after considering the cause, my lord, if any aggrieved person has shown the cause, my lord, then if any shown by any person in pursuance of a notice under section 4 and any evidence produced by him in support of the same and after personal hearing, if any given under subclause 2 of clause B of subsection 2 of section 4, the state officer is satisfied that the public premises are in unauthorized occupation, the state officer shall make an order of eviction for reason to be recorded therein, directing that the public premises shall be vacated on such date as may be specified in order, but not later than 15 days from the date of the order, by all persons who may be in occupation thereof or any part thereof, and any cause a copy of the order to be affixed on the outer door or some other conspicuous part of the public premises. So, my lord, these are the mandatory requirements. We were required to show our cause, but that opportunity has not been given to us, my lord. My lord, admittedly, my lord, this area has been, my lord, it has not been settled, or we are not residing any patta land, my lord. But at least, my lord, considering the requirement of the law, my lord, these are the requirement of law which is required to be followed, my lord.
Yes.
May I please, your lordship?
Yes.
Lordship, the petitioners claim to be erosion affected persons who are occupying the land. For a moment, I would take your lordship to NHA 3, which my learned friend has enclosed. It starts from page 42. 42, 44, 46. None of these persons are the petitioners
No,
here.
no, that is correct. That is
No, no,
correct.
wha-
Yes,
let me
please,
finish.
please, please.
If he claims to be erosion affected person, and he has attached these documents to show that he is a erosion affected person and the certificate has been issued, lordship, the whole stand of the petitioner is incorrect because these persons are not the petitioners here. Secondly, lordship, my friend submits about the procedure to be followed under the PPE Act. If your lordship will see, page 29, my friend has drawn your lordship's attention to this particular line. In this connection, proceeding against the unauthorized encroachers as per PPE Act 71 has already been completed, lordship. I have the records. The procedure under section 4, section 5 has been completed. That was by the estate officer. It was completed. They were asked to vacate the premises, but then we cannot forcefully vacate the people. We have to take help of the state government, the state machinery. So we have approached the state government. Now, the estate officer need not tell them again to vacate. That has been already done by the estate officer. So the submission made by my learned friend is not at all correct. Now, the divisional engineer NF Railway, before the petitioners are to be evicted, lordship, he has given an information that to please vacate. The procedure has been completed, lordship. And they have not gone for any
Were any
appeal.
notices properly served on these petitioners?
Lordship, so these notices, lordship, they have, most of these notices I have seen, they have neither received, they have not allowed to paste it. They are not allowed to paste it. And there are witnesses to that.
Yes, Mr. Guye.
My lord, with all respect to the submission made by my learned friend, my lord, we were not at all aware regarding the procedure which has been, my lord, carried
How
out.
will this court find out between
No,
your
let them-
statement
let
and his
them-
statement?
No, my lord, let them file an affidavit, my lord, showing before my lordship that how they have followed the procedure. These are only the
First
records.
of all, lordship,
No,
we
but
have not-
unless you satisfy,
No, my lord, we have, my lord, stated that we have not received any notices regarding the
mere
PPA.
statement is not enough.
No, my lord, they, because, my lord.
Do you have the records?
lordship, I have got photocopies of,
What does it reflect? Let us see.
this is an order passed under section,
No, the process by how notices have been issued.
that whole
What steps
record
have
I
been
do
taken?
not have, lordship. I got the,
That is their
what
case.
is the section 5.
Is their case that they have not been served on notice.
First of all, lordship, let them satisfy their cases, they are erosion affected persons.
Whatever it may be, they are unauthorized. They don't dispute that. But
We
there
are,
is a
we are
procedure
not saying.
prescribed. There is a procedure prescribed, which you say has been complied.
Now, lordship, whether the petitioners are the same people who are residing there,
Don't know
Yes.
that. It
that
not-
is what, lordship.
Yes, yes, my lord,
That is
otherwise,
what-
why you
If
will
they-
come, my
if
lord?
they would have been the same people, they would have been the erosion affected people. Where are their certificates?
Lord, we have a bulk of
Is it your
certificates.
case that these people are not even occupants of these lands?
Maybe, lordship,
No, not maybe. We want to know.
because no, their petition does not reflect.
My lord, we
Their
have,
petition does not reflect at all.
Lord, in paragraph 2, I have stated, my lord.
It's just a statement, lordship.
My lord, what to give more than a statement at this moment, my lord, we have the, my lord, we have bulk of records and bulk of certificate, my lord, for the paucity of time. My lord, around 40,000 people are residing there in, my lord. Is it possible, my lord, to
Lordship,
bring
every
all
5
those
minutes,
things?
lordship, their number of people are
My lord.
exceeding. It was less a few minutes back.
What was, according to the railways, the number of people available?
At that point of time when we had come, it was 154. 154 families were there.
Family.
My
You
instruction.
show us the record that you have, the notices were issued to these people residing there in terms of the provisions of the act.
I can do that.
When can you do it?
Let it be on Thursday, Your Lordship.
Thursday already. Heard learned counsel for the parties. The grievances of the petitioners are that their erosion affected people who were residing in the land in the Jagi Road Railway Quarry siding
Mine.
area at village Silbhonga, Morigaon, for the last around 40 to 50 years. Since they were not rehabilitated by the people, by the government, in spite of they being erosion affected, they were compelled to reside in this area. And they started working in the railway stone quarry, which was set up there. They are aggrieved by the notice dated 12/6/2024, which was served on, was it served or
No,
pasted?
no, it has been pasted in some of the places.
It was
They are
pasted
from-
in some of the sheds for the residences, or the houses of the
Mine.
writ petitioners, stating that they are to vacate this land in terms of the proceedings undertaken under unauthorized encroachers under the PPE Act 1971,
Yeah.
as they have been declared unauthorized encroachers. Stop. They were directed to vacate the land within 7 days. Stop.
Yeah, okay, I'll try to make it.
The petitioners are before this court that they did not receive the notices and no proceedings as claimed to have been completed under this PPE Act of 1971 was ever undertaken by the Railway Authority. Stop. Being aggrieved here before this court that the eviction process undertaken pursuant to the impugned notice dated so and so is completely contrary to the provisions laid down in PPE Act 1971. And therefore the same cannot be permitted to be carried on. So, para Mr. R.K. Dev Chaudhary, learned PhD, on the other end, disputes the contentions of the writ petitioner. He submits that the proper proceedings are as envisaged under the provisions of PPE Act 1971 has been was initiated, and it is as is apparent from the impugned notice that it is only after conclusion of the proceedings initiated under PPE Act 1971 against the writ petitioners that the process of eviction has been initiated by the notice stop. He submits that the writ petitioners are, although they claim to be erosion affected persons, are not the persons who are unable to support their statements by proper documents. So the certificates which are issued in respect of, in support of their claim that they are erosion affected have not been issued to the writ petitioners. Stop. He further submits that from the records it is evident that the notices were issued under the provisions of PPE Act 1971. However, there are instances where the affected persons refuse to accept these notices and consequently they had to be pasted.
But it was not allowed to be pasted.
It was in some cases, it was not allowed to be pasted. Stop. Therefore, the grievance of the writ petitioner that the process of eviction is reverse the provisions of PT Act 1971 is completely incorrect, and the railway authorities are required to carry out the process of eviction, as this is the railway land which is required for development and construction. Stop. He, however, submits that he does not have the records in respect of the proceedings initiated under PPE Act with him. He prays for
Till Thursday.
matter to be listed on Thursday, which is 27 June, on which date you would like to produce the relevant reports. And let this matter be listed on Thursday. Meanwhile,
I'm not accepting his prayer, Lordship. Because apparently, Lordship, these petitioners are not the same people.
the respondent railways will not proceed with the process of eviction undertaken until the next date fixed.
Lordship,
The
Uh,
government is,
the state government is also involved because the eviction process is being done by the
Will
state.
not proceed with the process of eviction undertaken through the state government of Assam until the next date fixed. Who appears? Mr. H. Sharma for the respondent 5678 will convey the orders of the court to the respondents forthwith in order to carry out the compliance court's order. So,
may I pray that
Mr. Yes,
my respected friend may inform about telephone, my lord, as the process has been already started.
the respondent, counsel for respondents are at liberty to inform will inform the respective respondents about the orders passed in court today. List on Thursday.
Oh, but
Highly obliged, highly obliged.
ಇದು ಮಾಡಿಬಿಡಲಿ ಅದು. ಅದು Welcome.
May it please your lordship. Okay, on the ground of the pavement, lordship, I'm praying for some time, your lordship, and moreover, lordship, there is a high
No,
possibility.
this is an old matter. On the
Yes,
last
lordship.
occasion, we were told that
Lordship, there is a
perhaps
high
they would like,
possibility, lordship, will be.
who's for the
between-
petitioner?
Lordship,
You are for the petitioner.
lordship, I'm appearing on behalf of Mr. P. N. Goswami, your lordship.
Is he appearing for the petitioner or
Yes,
respondent?
Yes, he's appearing for the petitioners.
On the last occasion, I was informed that instructions are awaited that
Lordship.
the writ petitions did not be pursued.
Yes, lordship. There are some undersettings are going on, and due to his father's illness, lordship, there he couldn't pursue with the clients, your lordship. That's why, so after vacation, let the matter be fixed, lordship. There is a high possibility, lordship, that this can be closed, your lordship.
It is submitted that the counsel on record, Mr. P. N. Goswami, is unable to appear in court because of medical issues concerning his family members, immediate family members, and therefore adjournment is sought for on his behalf. MS A. Gayan,
In item number 3, Manoj,
only in 3.
on the 1 and 2, Manoj Salan is
He
there.
was here, your lordship.
Yes, Manoj Salan, he was there.
CBI.
Learned counsels for the respondents do not oppose the prayer made. Let the matter be listed again
Any date after vacation.
month of July on 30th
30, much of it.
July.
Vacation 30. May it please your lordship. Lordship, in the earlier matter, lordship, there is an interim lordship that may be.
Whatever is there will continue.
Much of it.
Yes,
May it please your lordship. My lord, by this application, my lord, we have challenged the issuance of a so-called notice and the impugned order passed by the additional commissioner CGST Dibrugarh.
Why do you not go and appeal?
My lord, we have taken the specific reading in this case also, that the order is absolutely without authority, without jurisdiction, Your Honor. And
Why?
there is time barred also. That pleading we have specifically.
You go and
taken.
file an appeal before the authority.
My lord,
Why don't you file an appeal? There is a statutory forum.
that is right, my lord,
then-
but there is provision for depositing of the money
You
as well.
deposit.
And apparently the order is without authority of. Apparently the order is.
No,
time
show
barred,
us,
my
show
lord.
us, show us the apparent.
Apparent, my lord.
Yes, how is it apparently without
My lord.
jurisdiction?
May I take your lordship to page number 36? Page number 36, my lord.
Yes,
This is the Form 26 AS of the Income Tax Act, my lord. And this reflects whatever the receipt I have taken from the service recipient. This contains from 1st April 2016 to 31st March 2018 for the whole year, my lord. And now, my lord, the service tax was repealed from 1st July 2017. But they are charging the tax from entire year of 2017-18, which is without authority of law as provided under Article 265. Once the service tax is abolished, my lord, that was merged with the GST,
show us where.
my lord. I've taken the specific reading, your my lord, that this service tax is abolished.
It's a matter of fact. Everyone knows it's abolished from 1st of July 2017.
Yes, and
You show us from the demand notice that notwithstanding that the demand includes the
in
period.
in the demand notice, my lord.
Yes,
In the demand notice, they have taken the transaction that is at page number, proposed notice is at page number 71, my lord, no, my lord, 65,
yes.
page number 65. And particular page number 67, my lord.
Yes.
So the demand is financial year, 1 year 2017-18, 1 for 2017 to 36 2017. They are mentioning the 30th June, my lord. But the amount of this 8 crore, 9 lakh, 94 lakhs, 3,500 is for entire period. This is apparent on this Form 26 years. This is the entire period, my lord.
Where is Form 26?
The Form 26 AS is at,
36.
my lord, page number. Page number 36.
Yes.
For the entire period, this
What entire?
Indian Oil Corporation, 8 crores, 49 lakhs, 26,256. This is for the entire financial year 2017-18. And the date is also mentioning here the transaction date of March 2018. If your lordship can see the serial number, the date of transaction, my lord. The date of transaction is serial number 1, 31st March 2018. This is for the entire period, my lord. They had taken this entire period as up to March 2017.
So therefore go and appeal.
That is my first submission, my lord. This tax demanded by them is without.
Go in appeal.
My lord.
Go in appeal.
Once apparently, and number 2, my lord, this so-called notice is time barred.
Why?
Absolutely time barred, my lord. The so-called notice is dated, that is page number 65, my lord. This is dated 24/4/2021, and they are demanding the demand for 2017-18. This is absolutely time barred, my lord. And in the similar matter, similar case were entertained by this honorable court, my lord. Once the notice itself is without authority, without jurisdiction, my lord, it is absolutely time barred. Myself may
Go in
not,
appeal.
my lord.
Why don't you go and
Oh.
appeal?
For appeal, my lord, there are, I have taken the plea that once it is absolutely without authority, this court has jurisdiction.
Why do you
Similar
say,
matter, in the similar matter, court has entertained also, my lord. I have,
no, why do you say it is without any authority?
without authority, my lord,
Why?
once the service tax is abolished, and
Hmm.
for that period, I am paying the GST. That also I have attached here, my lord.
It does not reflect that this is service tax, does it?
Yes, it is reflecting it is service tax.
Where?
In the so-called notice itself and in
No, no,
the
in
input
the-
demand also.
In the form 26 AS,
Yes,
where does it show?
in 26 years, it is the transaction. Because that is for the income tax purpose.
That-
Where
that-
my money was tax deducted at source under the income tax law. They are demanding the tax on the basis of income tax record, which is also not all allowed.
What is the total amount reflected here?
In 26 years, it is reflected 8 crores 49 lakhs 26,256. And the period wise details is also mentioned there.
And
Date wise mentioned there.
where is that show cause notice?
So cause notice is 8 page number, my lord, 65, and the relevant is page number 67. Eight crores 9 lakhs 43,500.
And what is the amount reflected here? What is the amount of tax you have deposited here total?
That I have given in my reply, my lord, to this so cause notice. That is at page number 77, my lord. I have specifically given the reply that this is the only period which is included in the service tax, my lord. That is 2 crores 34 lakh 51,896.
Yes.
We need to obtain instruction.
Third learned counsel for the parties issued notice for which. Where is the impugned order?
Impugned order is at page number, my lord. 132.
Petitioner is aggrieved by the impugned order in origin. So and so dated 27/3/2024, whereby the following was imposed. Page 28, para 28, 143. Quote ABC. So, being agreed, the petitioner is before this court. It is submitted that the order is based entirely on the details obtained from the income tax department with respect to the transactions of the petitioner with the various authorities, and the entire impugned order is issued taking into account the services, taking into account the transactions reflected in form 26 AS under the Income Tax Act. Stop. Learned counsel for the petitioner submits that there is no service tax with effect from 1st of July 2017. However, the departmental authorities, without any application of mine, has taken into account the transactions undertaken by the petitioner during the said period, which although falls under GST, but on the basis of the form AS form 26 AS, the entire period, entire transactions reflected beyond 31st of beyond 30th of July 2017 are also shown as transactions under service tax, and accordingly proceedings are drawn up and the demand has been raised by the department. Being aggrieved, he has approached this court. Para MS so and so appears for the respondents, submits that instructions are necessary in the matter. You represent
Lordship, 234.
234. MS so and so appears for respondent number 1. Since the respondent counsels are have already appeared, notices of waive, extra copies be furnished within a period of 1 month from today. Let the matter be listed after the returnable date. Meanwhile, in terms of the interim order, impugned order, no coercive steps be undertaken on the petitioner till the next returnable date. Matter be listed on 2nd of August.
Much obliged.
Highly obliged.
May be Lordship Valor. The Boitamari Ansalik Rangali View Samileni is a society minor which is applied for registration the government of Assam.
Yes, government, what do you say? Lottery? You obtain instructions. When is your lottery? Schedule.
Yes. So civil manner, this manner. The permission afforded and we have published the lottery manner.
When is the date of draw?
Yes. Page 19.
Third Learned Senior Counsel, Mr. R.P. Sharma, assisted by MS so and so. MS S. Sharma appears for
All the respondents.
respondents. Petitioner is aggrieved by the impugned order dated 7/6/2024 issued by the District Magistrate Bongaigaon, whereby there was a ban has been imposed on all lottery activities undertaken by all religious and cultural organizations. And the same order also supersedes earlier previous permissions which may have been granted by the district authority. In terms of this order, the lucky draw called by the petitioner organization has been cancelled. Stop being aggrieved there before this court. Issue notice returnable 3 weeks. Respondents will obtain required instructions. Matter be listed after the returnable date. Since the government counsel appears, this is a waived, our extra copies be furnished within a period of 1 week from today. After returnable date. Anything more you want?
I want the interim, my lord.
You want an interim?
Yes.
For a lottery date which has already passed.
My lord, with due permission, SP inquired.
When was the date?
Date, my lord, I'm also confused.
So you tell us on the next date. On the next date.
They say 14th April, 14th May and 15th May.
It's already gone.
Gone, we will extend it.
You'll extend it, but we can't grant you an interim to hold the lottery because then what will be left to be decided in the petition?
Anyway, let it come after the reasonable date and in the meantime, my lord, we'll fix the date and inform you.
Yes, yes. After returnable. Please get your instruction.
Problem.
Yes.
May I please your lordship? Lordship, this is a matter relating to lordship service tax for the assessment year 2015-16. Lordship, I'm a lordship subcontractor working under the works contractor, and lordship, I'm lordship covered by the mega exemption, notification, and exempted unit. Lordship, my main prayer before your lordship is that my demand cum SOCOS notice as well as the impugned order is both are time barred for the assessment year 2015-16. Lordship, for that, lordship, let me take your lordship to the provisions of law in this regard. Finance Act.
Service tax.
Yes, your lordship.
Do you have the provisions enclosed here?
Lordship, I have given the
Yes.
what's it, section 73, which deals with lordship recovery of service tax not levied, paid, or short levied or short paid or erroneously refunded.
Yes.
Lordship, section 73, subsection 1, lordship, lordship will find at page 16.
Yes.
Where any service tax has not been levied or paid or has been short levied or short paid or erroneously refunded, Central Excise may within 30 months, lordship, this is my first lordship, from the relevant date serve a notice on the person chargeable with the service tax which has not been levied or paid or erroneously refunded. Lordship, there is a proviso. 30 months is lordship in normal case, but there is a proviso that where any service tax has not been paid or has not been short levied or short paid erroneously refunded by reason of fraud, pollution, willful misstatement or suppression of fact or contravention of any provisions of this chapter or of rules made thereunder with the intent to make payment, evade payment of tax, the person chargeable will tax or his agent, the provisions of this subsection shall have effect as if the word 30 months, the word 5 years has been substituted. So lordship, firstly, lordship, 30 months is the lordship basic period and it can be extended up to 5 years. Lordship, this is for so far as notice is concerned. Lordship, so far as passing of the order is concerned, lordship will find at page 40, page 18, section 4B.
Yes.
4B says, lordship, the Central Excise officer shall determine the amount of service tax due under subsection 2 within 6 months from the date of notice where this is possible to do so in respect of case falling under subsection 1. Within 1 year from the date of notice where it is not, where it is possible to do so in respect of cases falling under the provisions of 2 subsection 1. So lordship, 6 months and the lordship outer limit is 1 year. Within 1 year of the service of notice, the order ought to have been passed, lordship. Lordship, in my case, lordship, firstly, lordship, I'd like to take your lordship to page number 56, which is my SOCOS notice.
Yes.
Lordship, annexure 4, page 56, my SOCOS notice is 19/20/2020, which is lordship for the assessment year 15-16.
Yes.
Lordship, for 15-16, lordship, it should be 30 months. Lordship, 30 months had ended in the year 2018 itself. And lordship, the
Now, what is the date of the SOCOS notice?
19/10/2020, lordship, page 56. This is the demand cum SOCOS notice which was issued to me. So lordship, 30 months had elapsed. So lordship, they have undertaken the extended period of limitation. This is within 5 years, but 30 months have elapsed. Lordship, my first submission is that lordship, there was no fraud or willful misstatement on my part because I am a contractor and I am lordship exempted from payment of service tax. And lordship, so lordship, this should not have been evoked. Lordship, but my main prayer is lordship, I may find that annexure 6, page 87, the order which has been passed. This order has been passed on 27/3/2024.
Yes.
Page lordship 87, lordship will the date lordship will find it page 97.
87 also.
87, yes, lordship. The 27/3/2024 is the order, lordship. So it should have been passed within a period of 1 year. That is a maximum period. It has been passed after lordship almost 4 years. So lordship, that order is barred by limitation.
Where is the specification that the order has to be passed within 1 year?
Lordship, that section
4B.
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 Yes, your lordship. 6 months and maximum 1 year, lordship. But the order was not passed within a period of 1 year. This is an ex parte order, lordship. Other grounds are there that it is exempted, and my lordship, in respect of exempted unit, lordship, there are many similar order which has been passed by this honorable court. But lordship, at this moment, lordship, I am.
Yes. What do you say?
Lordship,
Page 90,
90.
90. Why the department is invoking the recovery of the service tax, section 69 of the Financial Act? May I read your lordship? From the above facts, it appears that the said notices contravene the provision of section 69 of the Financial Act. They fail to take service tax registration. Number two, contravene the provisions of 68 of the Finance Act 1994. They fail to deposit the service tax in a manner within the time limit prescribed. Number three, section 70, rule 7 of rules 1994, they discharging from the prescribed day and disclosing complete details. So these are the sections which have been invoking against them. And thereafter, why the sections have been in place for 5 years, that have been mentioned in 1.4 details. So our demand notice is around 41 lakhs, 4,349. And that is the case. They have, whether they have been mega exempted or negative list in the category, that has to be satisfied.
No, but under the prescription of the act, you have to complete within 1 year.
Lordship. But when there is a suppression of,
Even then, within 1 year, after issuance of notice.
5 years is the extension period. That is the reason they have mentioned in 1.4. Why the invocation of the subsection 1 of the 73 of Financial Act 1994 has been implied to them.
Third Learned Counsel to the parties issued notice, written about 4 weeks. Petitioner is put to challenge the impugned order dated, impugned order in original dated 27/3/2024, issued by the Office of the Assistant Commissioner, CGST and Central Excise, Bongaigaon Division, hereby the following has been imposed. Page 96, para 4.1. Petitioner challenges this impugned order as the same thing violative of section 4 capital B of the
So clause 7, 4B of section 73.
4 capital B of section 73 of the Service Tax Act, wherein the order under 4B is required to be passed within a period of 1 year from the date of notice. So, Learned Counsel to the petitioner submits that the period in question is the financial year 1516. And in terms of the provisions of the Act, the same ought to have been completed within a period of 30 days. However, invoking the provisions of Section 73, the period has been extended beyond 5 years, although there is no suppression or willful default by the petitioner in disclosing or in payment of the service tax. However, notwithstanding the said provision having been invoked, the show cause notice was issued on 19/10/2020, and ordinarily the order is required to be passed within 1 year from the date of issuance of show cause notice. However, the same was issued on 27/03/2024. As such, it's stated that, submitted that the same is a clear violation of the mandate of the provisions of the Act. Mr. Dr. Gogoi, Learned Counsel appearing for
GST, BN Gogoi.
For all respondents, except notice, he submits that the orders have been passed in terms of the provisions of the Act and no interference is called for. Issue notice, return every 4 weeks. The respondent will file the response in time. No coercive action against the writ petitioner until the next date fixed. It's on 2nd August. Coercive action in terms of the impugned order.
Much better.
Yes. Serve extra copies within a period of 1 week.
Please, your lordship. In this case, my lord, the petitioner has approached before this honorable court for the second time. Some of the petitioners also earlier approached before this honorable court, my lord. For acquisition of the land, they are, my lord, seeking the appropriate compensation from the respondent authorities, my lord. I'd like to draw your lordship's attention, please, kindly at least 33, your lordship. The deputy commissioner, my lord, may I read 33.
Yes.
My lord, the deputy commissioner issued this order, this letter, my lord, today, to the executive engineer, Golpara Water Resources Depot Division, my lord. Acquisition of land for construction of retirement of BUIK from Belku City Beldu from CH 33.94 km at Joleshwar connecting to DRDA bank at Nishinpur, including a measures allocation response, my lord. With reference to the above, I am to inform you that an estimate for an amount of rupees 4 crores 12 lakhs 83,827 rupees only, with the copy of Jira's assessment list and the land valuation statement has already been sent to you for placing of estimated fund against LKS number 1. But the same has not yet been received till date by this office. You are therefore once again requested to place the estimated fund today undersigned immediately for avoiding further legal consequences, my lord. This is in the year 2017, my lord. And thereafter, some of the petitioners submit application for non-inclusion of their names in the under the scheme, my lord, at least 35, my lord. And thereafter, their names and tag numbers were included, my lord. My lord. Now, my lord, the petitioner has sought for compensation, my lord, under the as their lands were acquired by the respondent authorities, my lord. In this case, my lord, a notice may go to the respondent, my lord. In the
What
meantime,
was
they
the direction in the earlier?
Yes, my lord. At phase 48, my lord.
Yes.
At phase 48, my lord.
Has the award been made?
No, my lord. No, my lord.
Then?
Lordship, I'll get some time, lord.
Heard the council for parties need to notice return in Mr.
Notice may go, my lord.
These are my peer for respondents.
1 and 4, Lord.
1 and 4. Mr. Sharma for 3 and 6. And Mr. Chaliha for respondent number 2. Who appears for 1?
Lordship, I am.
Extra copies be furnished, matter be listed after return of date.
When the petitioner husband was picked up and he was killed by 7 police officials and 1 private person. This is on the basis of the charge sheet and constituted by an order of this court. The
You'll have
lordship
to-
looks
you'll
into
have to
at
issue
least
notice,
notice
yeah.
yesterday.
You have to issue notice here. Heard?
I have not let government respond calm
That's
while
right.
they are sitting over the matter. We have also prayed for appointment of a public prosecutor, considering the gravity of the matter. That
No,
also
but they
there.
have not issued the sanction as yet.
Sanction is also there and also request for public, what is their view in the
No,
matter?
no, unless the sanction is
Yes,
issued,
yes.
where
Yes.
is the
Yes.
further
Yes, yes.
sequel?
The
He
case
said.
is proceeding well.
Heard Mr. B.D. Das, learned senior counsel, assisted by Mr. Tota. Hausen. Okay. MS S. Sharma appears
All
for
the response.
all the respondents. Should notice returnable 4 weeks. If the respondents are represented by the government advocate, notices the waived, extra copies be furnished within a period of 1 week from today. Matter be listed after the returnable date. You want a fixed date?
Fixed date would be better.
5th of August?
My lord, I have dwelling house as well as one factory at Devasthan in the district of Hojai. There is a river that is called Jamuna River. the private respondents started construction of a bridge under the Assam Mala scheme. The river was,
We'll issue notice first. Let the government respond. In respect,
we have already filed petition before the authority.
you have,
Yes, ma'am.
but no.
No, nothing, no
No
action is
orders.
taken. Page 25, para 5. And also another.
Are you praying for a disposal, for a
No, I
direction
don't
to
know.
dispose of?
Lordship, already they may assess my damages I have already
So we'll
suffered.
issue notice here. Heard Mr. M. Mahmood, Learned Counsel. And MS M. Borman and
I'm for four only, my.
hearing for the respondent. Let notice be issued. Returnable 4 weeks. MS S. Sharma IPS for 1, 2, and 3. MS M. Borman for 4.
No.
Only 4.
Yes, ma'am.
Let steps be taken by usual course registered post on the respondent 5, 6, and 7. Extra copies be furnished to the learned government advocate that will be listed after the return date. Right.
May I please, Lordship, matter may be taken at 2 p.m. Lordship.
Why? What is the matter?
Why, Lordship, I am not aware of the matter, Lordship. Contacting advocate, I usually probably he is in a hospital, Lordship. He is available.
Second up, all right. Yes.
This is regarding execution, the husband of the petitioner died in motor accident.
All right, heard and counsel to parties issue notice. Returnable 4 weeks. MS M. Borman appears for
2-6, my.
3 to 6. MS G. Hajarika for 1. Mr. Choliha for respondent number. Since the learned government advocates represent all the respondents, notices are waived, extra copies be furnished within a period of 1 week from today.
Like last week, your Lordship disposed of the matter in the motion. Last week.
You want a disposal?
Yes.
We dispose it off.
Look, notice has to go first, madam, because they got.
Let them get their instructions first. Similar.
No, my lord. In this case, my lord, the petitioner, it's a businessman, my lord, he was conducting business in the old market of Bilashwara town, my lord, and he was evicted with the assurance, my lord, the new building was constructed, thereafter the new room will be allotted, my lord. But after construction, my lord, the room was allotted to the respondent number 7 to 11, my lord, without issuing any notice, my lord. That is why, my lord, the petitioner and other person submitted representation, my lord, page 15 onwards, my lord. So at this stage, my lord, I prayed for direct the respondent to at least dispose of the representation, my lord, page 15 and onwards.
Heard learned counsel to the parties. Petition is aggrieved by non-allotment of a room in the newly constructed building in the for the
By the
vegetable
municipal
market in
board
the Bilasipara town under the Bilasipara Municipal Board. Stop the petitioner claims to have conducted the business in a room taken on rent,
Yes.
on rent.
Yes. My lord, actually, at that time, my lord, without rent, my lord, in the open space, my lord, in the vegetable.
Claims that he was operating in the old building, selling. What are you selling? Vegetables.
My lord, there is no, we have not annexed the input order, my lord, annexer 15, my lord.
Was running a vegetable shop. Subsequently, there was a decision to demolish the old building and construct a new one. petitioner filed a representation stating that room numbers 270, 271, 272, 273 have been allotted to the private respondent, whereas he was not given any space.
No, my lord. Page 15, my lord, paragraph 3, my lord. Constructed 11 numbers of room, my lord, and 4 numbers of room already allotted
Out
to.
of the 11, total 11 number of rooms, stop. 4 number of rooms have been allotted to the private respondent without any rhyme or reason, whereas petitioner and other similarly situated persons have not been allotted any rooms. Stop. Raising this objection, he filed a representation before the authorities on 6/6,
6, my lord.
2024. Said the representation was addressed to the DC Kubri as well as to the SDO Civil Pilasipara. So the same although pending, has not been disposed of as on date. The limited prayer of the writ petitioner is for a direction to the Deputy Commissioner Kubri to dispose of the writ petition, to look into the grievances ventilated by the writ petitioner and dispose of the same by passing a speaking order. The said prayer is not objected to by the counsel for the respondent, by the government advocate appearing for the state respondent. So, considering the limited prayer, this writ petition is disposed of with the motion state without issuing notice. Stop the impugned, the representation dated 6/6/2024 stated to have been issued by the stated to have been submitted by the writ petitioner before the DC should be considered by the DC to agree. Stop. The grievances ventilated by the petitioner will be given due consideration by the DC to agree, and thereafter the same shall be disposed of by passing a speaking order. And the DC to agree after consideration of the grievances ventilated by the petitioner will pass a speaking order. Stop. Any such order that is passed will copies thereof will be served on the writ petitioner. Stop. This order is directed to be carried out within a period of 30 days from the date of receipt of a certified copy of this order, along with a copy of the writ petition to be filed before the writ petition. DC to be.
And my lord, I pray for interim, my lord, since
Interim.
yes, my lord, till disposal, my lord, the remaining 7 rooms may not be allotted to other.
No. We can direct a disposal within 15 days. Is it
My lord.
possible?
My lord, 15.
30 days required, my lord,
30.
because now a flood situation is there.
Yes, 30 days.
At least 1 room may be kept in vacancy.
You have asked for a disposal, we have given you a disposal.
My lord. Obliged.
May I please your lordship? Mr. A.R. Bhuya is on leg, so kindly pass.
We'll issue notice, please tell him that.
My lord. I thought Mr. A.R. Bhuya is on leg, so kindly pass over the matter.
Second half. Yes.
Obliged, sir.
Yes.
Lordship, the petitioner during the relevant period, that is assessment year 2010-11, was in the Merchant Navy. And Lordship, may I immediately turn to the circular? Income earned or accrued while being in service is not taxable. That's page 70, your Lordship. This is the page 70, your Lordship.
Tax free.
Yes, your Lordship.
How lucky.
Yes, merchant. It's anyway a lucky profession. It's a good profession. So there was the petitioner maintains what is called the NRE account. So there was a confusion. In fact, the circular came up because money used to get credited into their account and tax authorities used to tax. So Lordship, page 70, representations have been received in the board that income by way of salary received by non-resident seafarers for services rendered outside India on board ships, foreign ships, are being subjected to tax in India for the reason that the salary was being received by the seafarers into the NRE account. That's a non-resident external bank account maintained in India by the seafarer. Paragraph 2 is relevant. The matter has been examined in the board. Section 5(2)(a) of the Income Tax Act provides that only such income of a non-resident shall be subjected to tax in India that is either received or deemed to have been received in India. It is hereby clarified that salary accrued to a non-resident seafarer for services rendered outside India on a foreign ship shall not be included in the total income merely because the said salary has been credited in the NRE account maintained with an Indian bank by the seafarer. Now, what happened, Your Lordship, is page 37. When I filed my returns for assessment year 2010-2011, Lordship has serial number 4 in the body.
Yes.
Net tax payable, total salary and interest exempted from Income Tax Act. This is what we said. Next page again is indication that it's in US dollars, so it's an NRE account. And again, right at the end, total salary and interest exempted from Income Tax Act. So that was a position. Declared 37 lakhs as income, but said that is exempted. And this is a position in 2010-2011. Now what happens is, when I file my return for assessment year 23-24, that's at page 39. 13 years after, there was zero income, and I claimed a refund. Refund, because there was TDS cut, so I claimed a refund. And this is
TDS from?
Lordship, and there was no income, but there was some TDS, something else, which is completely unrelated. So we're not concerned with this amount, Your Lordship. What happens is when I make a claim for this refund, I get to know, and that's at page 71. And this is a grievance that I raised. Lordship has page 71. It's grievance description. Lordship, that column?
Yes.
Yeah. Lordship, dear sir, my portal is showing an outstanding demand amount of 16.6 lakhs pertaining to assessment year 2010, having demand reference number so-and-so, dated 12/3/13. My this year refund, 2023-24, kept on hold due to this demand. This demand is very old, is not in my knowledge. Kindly look and drop this demand, please. Also note that I have received, please, Lordship, it's important. Also note, I have received refunds in earlier years, wherever applicable. So this demand may be erroneous. So what has happened, Your Lordship, is a 2010-11 assessment, they discover now in 2013-14 and set off a 17 lakhs demand of 2010 against when I asked for a refund. Lordship, may kindly now go to page 79. This is what they have to say. There were a lot of communication to and fro. I will not trouble Your Lordship with that. Page 79. We wrote to them on page 71, and then after that also we wrote to them. And then the relevant response is at page 79. Lordship has page 79?
Yes.
We'd respond to your request made through so-and-so. The system screenshot of ITR processing details in your case for AY 2010-11 attached to this letter. Please note, as per department's so-and-so record, so-and-so was filed before the erstwhile ITO, showing total income of 37 lakhs, and the ITR processed under 143 on 22/3/2013, raising a demand of 16 lakhs. So on my assessment year and original return of 2010-11, they claim in 2023 that they have raised the demand on 22/3/2013. We have never received this. And as I mentioned in page 71, I have got refunds from 2010 to 2000 now 23. I have got refunds. They've never woken up. Suddenly they wake up and they realize that there may have been income tax. And Lordship, what is crucial is this: the impugned order, which is at page 87. We then make another grievance at page 83, Your Lordship, where we explain everything. We give all the documents that I was not working here, etc. Now, the order, page 87.
Yes.
And this is one of my emails being converted to a rectification proceeding. 154, which is a rectification proceeding. Lordship, page 3 is where they cull out my entire email, which is they treat as rectification application, where I say that I was in continuous service. I attach passport, I attach everything. Now, Lordship, what is important is paragraph 5. They don't dispute any of this. Look at what they have to say. Paragraph 5, page 88.
Yes.
On perusal of your aforesaid return of income dated 10/2/12 and computation of your income submitted herewith, it is evident that you have not claimed any exemption under the provision of Income Tax Act while arriving at your total income of 37, but only stated that your income is exempt. So my nature of income depends on what I'm stating. Your return of income was accordingly processed under 143 on the total income shown by you therein, whereby demand was raised. So this is the understanding.
Just 1 minute.
Yes, Lordship.
Yes, please.
So, Lordship, the ground is I have not claimed an exemption. So, Lordship, we've again gone back and saying that, listen, that's a clerical error at worst. My nature of my income doesn't depend on the fact that I have not said, please exempt. I've in the end, I have declared. So what typically should have happened is I should have done a nil income and not raise anything. Lordship, the reason I'm troubling you with all of this is I filed an appeal on 6th of November, 2023. Various grounds. Most important substantive ground, it's not taxable. So if it's not taxable, you can't tax me because I did not say so. It was the nature of the law does not depend on what I claim in my original returns. Though I have indicated clearly that it's exempt. Even technically, Lordship, that 143 has not been intimated to us. That's another ground in appeal. That's at stage 1. Again, at 245, when you rectify also, you're supposed to intimate, you don't. So you've done everything that you've done on your own. So, but that is our ground of appeal. A problem that I face today is July 31st is nearing. There is a demand of 16 lakhs on us of the last assessment year. This assessment here, if I don't file, I will again be confronted with that. Unfortunately for me, the appeal is not getting listed. And there is no way I can get it listed. Since November, it's not. So, Lordship, my prayer is, pending appeal, I should not be confronted with coercive. Because under the Income Tax Act, after 13 years, I'm 61 now, my properties could be attached and everything, a recovery proceeding can go on as they want. So my prayer to your Lordship is very limited. I have no way of going and getting my appeal expedited or listed. Since November, it's not even listed once, even to make a claim for interim.
It's faceless. Is it a faceless appeal?
No, Lordship.
Is it under the faceless scheme?
Not because it is before the commissioner at Guwahati Road.
In person?
Yes, in person.
Oh, it's not on.
Lordship may
They
take
are
up
there.
tomorrow. I'll obtain instruction what is happened to the appeal. So since appeal is pending, it may take up tomorrow. I'll obtain instruction.
Yes. You may serve him an extra copy.
Yes, Lord.
Heard. Mr. SCKL, Standing Counsel Income Tax, prays for a day's time to complete his instruction. He submits the matter tomorrow. Tomorrow or day after?
Yep.
Day after.
Yep.
Which is the day after.
Much.
David. The petitioner before the Lordship there the horse pilgrims of the 2023. As per admission, the petitioner they applied for the horse and they are.
Some orders have been passed by the court.
My lord.
You want a similar order?
My lord. I have an extra.
Learned counsel.
Page 54.
Who's for the respondent?
Respondent Miller, that is a
Union.
Central Government Committee. Miller.
Yes, MS Egayan for the respondent number 1. Similar restrictions disposed of by the coordinate benches, council parties agree that the matter may be disposed of in similar terms. Accordingly, the order disposed of. Disposed. Yes.
Within a period of only 45 days.
Whatever is there.
I'm
Whatever
for only-
period is there.
That is more time is
45 days. All right. 45
I'm
days.
for only one, my lord.
Yes, we have recorded only
Yes,
for
ma'am.
one.
Yeah. Must.
May I please your lordship? The respondent authorities have complied with the order.
They have
Complied with the order, lordship.
MS
ADECA.
huh?
ADECA.
ATECA appears for the petitioner, MSDS Neo for the respondents. Both counsels of the bar submit the directions contained in the order dated
15/6/2022.
15/6/2022 passed in WPC 1834 of 2022 has been complied with. Stop. Taking into consideration the submissions made by the respective councils, the court is of the view that the further proceeding in the contempt petition need not be continued, and accordingly the contempt petition stands closed, stand resolved. Yes.
May I please your lordship? Lordship, on the last occasion, the opposite party prayed for 2 weeks' time to file their affidavit.
Yes, yes, yes.
1 week time.
Mr. H.K. Sharma, learned counsel, appearing for respondent 6, prays for further week's time. File 1 week time to file the affidavit. Any affidavits by finance?
Lordship, from the health department, Lordship, we will be filing our affidavit. Lordship.
Similar prayer is also made by the learned counsel, appearing for the
Health department.
matter be, health department. Matter be listed again after reopening on a date to be fixed by the registry. Respondents are in the meantime are permitted to file their counter affidavits as prayed for.
Much of.
Your lordship, private responses have filed their affidavit today. We have received a copy. Lordship would file to we'd like to file a reply.
Yes. Mr. Gupta.
Milords, the last date, Milords had called for report. Milords, they can file their reply. Milords, had expressed that they'd like to file a reply in the morning itself. The report has been filed by the Learned Registrar Judicial Milords. It's in the office note dated 3rd of June. Lordship had called for it, para 5 of Lordship's last order.
So certified copy is necessary, which is not filed.
The page which is my senior, Lordship.
Huh?
The certificate copy which we have obtained on that date, Lordship. The copy we have annexed in my petition, Lordship. It's my senior, Lordship. I'm led by senior counsel.
No, we are asking you whether a original certified copy was filed along with the writ petition or not.
No.
It was not filed. When the rules require, so this will require an inquiry as to how the registry is allowed. In terms of the earlier order dated 22/5/2022, whereby the Registrar Judicial directed to cause an inquiry and give a report as to whether under the rules, the Guwahati High Court rules, certified copy in respect of challenges made by way of an appeal or writ petition of the subordinate court's orders, certified copies of the said order are required to be filed. This is a writ petition file.
Yes.
In view of that, in view of that order, the Registrar Judicial has placed a report before this court. As per the report, referring to Rule 1 and Rule 9, Chapter Roman 5, Guwahati High Court rules, the Registrar Judicial has held that orders appealed against, certified copies of judgments or orders appealed against will be required while filing an application challenging the said judgments or orders. So, the report as directed by the court is considered and accepted. So, further orders, as may be felt necessary, will be issued by the court on a later date. So, learned counsel for the petitioner submits that he seeks, he prays for certain some time to file reply, the affidavit filed by the writ petitioner. Sorry, respondent. Prays for 2 weeks further time. Prayer made is not objected to by the counsel for the private respondents.
5 and 6.
You are filing reply against the affidavit filed by private respondent.
Yes, sir.
Accordingly, let the matter be listed again after 2 weeks. On a date to be fixed by the registry. Mr. Talukdar, you are hearing? Mr. P.J. Talukdar, it is for respondent number. for respondent 2, 3, 4. 2, 3 and 4. Please report it. We'll think about it. Let us, what orders we can pass.
Also, we have taken steps, my lord, on respondent numbers 3 to 7, my lord.
Counsel for the petitioner submits steps on respondent 3 to 7 have been taken. Office registry to verify and pass necessary. Registry to verify and make necessary endorsements. List the matter after 4 weeks.
Interim may be continued.
MST Hazarika appears for the respondent.
Interim,
Hmm?
interim order is there, my lord. That may be.
Interim order and let the matter be listed on 31st of July. Interim order to continue till the next date fixed.
My lord. Obliged, my
Yes, respondent.
Srinath is appearing, he is late for another.
Who?
Srinath is there, my lord, he has received instruction. He will taken after.
What, have you visited the premises?
No, my lord, we have invited them, my lord. They have not.
In my case, my lord, so far as the PWD is concerned, my lord, they say that it's functioning normally. You can't say whether it will be shifted or not. But regarding the commitment made by the before this honorable court that within 60 days they will shift. Yes. In this regard, my lord, their contention is that, my lord, for last 1 year they have been postponing the entire issue. And my lord, for this particular building, the work has not been could not be completed.
So we'll direct them 60
Because
days.
July
they'll
is the
vacate.
last date, my lord, by which this particular project was supposed
No,
to be
the
completed.
direction will be for vacating within 60 days,
Yes.
failure of which any
Demolition.
protection will be vacated without any reference to the court.
That will be. That, my lord, let him come, my lord.
All right, we'll take it up at second half.
Meanwhile, if he comes, meanwhile, I am waiting here. Otherwise.
Yes, Mr. Roy.
They were supposed to obtain instructions with regard to my cancellation, my lord. Because GST was cancelled without providing any opportunity of hearing, my lord.
Yes, who's for the GST?
Mr. Gogoi.
Mr. Gogoi.
My instructions are awaited, my lord. I can say, my lord. Your civil posted on 22nd, my lord.
22nd.
Lordship may 15th, no 16 or 25th, my lord. Lordship allows.
Lordship.
25th.
25th,
my lord.
25th July.
Deeply
25th,
obliged.
otherwise the hearing day, my lord. Let it be, my lord, either 24th or 26th.
My lord.
You file a affidavit, my lord.
26th
Yes.
Deeply obliged.
July. As submitted by both counsels, permitting the respondents to complete their instructions. Yes.
Sorry to come and cancel everything. Interfere procedure.
Have you gone through this? You can give him a call.
Today morning I have received it.
So they are pursuing in the matter.
She has been missing since 24 October 2022.
What is your prayer in the writ petition?
Mainly to investigate the case to the CBI Lordship. Or otherwise to a special investigating team with highly experienced police officials in solving the kidnapping cases. At page number 24, Lordship. Third prayer is CBI.
The victim was married.
She was married, but due to domestic process, she came out from. She was thrown out from her husband's house, and she was now residing with her parents.
Okay.
Now, parents have strong suspicion against the NSC commando also. She was having love affairs after coming out from her husband also. Lordship may post this matter after 2 months with a press report to submit to by the CID.
What is CA verification? Number 3.
All details, I think, my lord.
How can it be
Related to
qualified?
mobile number of the.
CA, serial number 3.
Yes, my lord. Abbreviation I could not say right now, my lord. But his phone number of the husband was in my lord.
Pursuant to the earlier orders passed by the court, the learned government advocate has placed before the court a report by the SBAHT CID Assam in respect of the investigation carried out regarding recovery of the daughter of the writ petitioner claimed to have who went missing on 24/10/2022 from Silchar town. In terms of the said report, expert opinion from regarding the call details which have been sent for examination connected to the seized mobile handset of a suspect Amit Sinha are still awaited. So, meanwhile, the investigating authority are in liaison with the Interpol for issuance of black notice within court. So, process for issuance of yellow notice within courts is also underway. So, let the investigating authority update this court on in respect of the opinions received from the opinions that may have been received from the expert in respect of the call detailed examination, all detailed reports, as well as issuance of the notices referred to in the communication dated 21/6. Depending on the information that is placed before the court, further orders, if required, may be passed by this court. List again in the month of July, on 29 July.
Obliged, Lordship.
Yes, Mr. Borbora. Your adversary is here.
Yes, my lord.
Yes.
Rest of the things are no problem, but the lockers are put very carefully and systematically installed.
60 days time. We want 60 days time.
I have received the instruction. Kindly have a look at the instruction below. In fact, Lordship has already seen that the bank has got times from the month of March 2023. More than a week, more than a year time they have got. It's a detailed instruction, Lordship may kindly come to
Give them 2 more time, 2 months more.
para 6 and 7.
Hmm.
Kindly in the next page, kindly see para 6 and 7.
Yes.
Otherwise, it's a detailed report. I'll take your Lordship to para 8 also. As per letter received from HDFC Bank authorities dated 30/3/2023, they have prayed for an additional period of 1 year, after which no communication was received from the bank authorities. They have now approached the court. The circle officer, Sonari Revenue Circle, by letter number so and so dated 22/4/2024 has issued notice to the Ahmadi Begum. Ahmadi Begum is the owner, and she has already received the amount to vacate the building Damas complex as the land has already been received. At the compensatory amount by sanction number so and so dated 23/3/2024. The bank has got ample time to vacate the land. And kindly another aspect, Lordship may kindly see, the PWD department has also given an instruction, and that if at this stage, that the kindly see, para 7, the
No, everything I understand. They have not vacated their tenants.
they are tenants.
Right.
But the
Now the question is,
drain has to be constructed there.
no,
And
I agree.
Lordship.
What is the difficulty in giving them a final opportunity of 2 months
But
to vacate the premises?
1 year, my lord, already they have passed.
We have
March
understood your
2023.
instructions, Mr. Nath.
And my lord,
You
now,
tell us that this extension of 2 months is going to be so fatal.
Lot of things are to be
that
completed.
the contract cannot be carried out or something like that.
Last date
Or
of
there is a danger to life and limb to people
yes,
living
my lord,
around.
the original date of completion is 25/8/2023. Now the extended date of
Okay,
completion
how
is
long does it take for you to construct it?
now, my lord, I'm just coming to that, my lord. Before that, I'll just indicate that the date of completion next now is 26/7/2024, July 26. And my lord, if the drain has to be constructed, thereafter the road will be constructed, my lord. If the granting of additional time, it will lead to additional escalation of price.
Tender will have to be floated for construction.
No, it is
Two-way bid, my lord.
79.
Reality is there.
Where is that extension of time?
Well, the PWD instructions is
Our part is that the respondent side, I would say that Lordship may based on 30 days time, based our way, and based 30 days.
para 16 kindly similar in the instruction 79% has already been done, my lord. The last paragraph of the instruction.
When did you issue the notice for vacating premises? When was it issued?
My lord, it was issued paragraph 6. That is what I have written, my lord. para 6 months. On 30/3/2023, they have paid for 1 year time.
When was your tender floated?
Instruction is before your lordship, but the PWD instruction is before.
Wish to
It's not
vacate,
here, it's not here. When was the tender floated?
not yet.
When was the work undertaken?
79% work is there.
When were you, since when did the work, since when was the work undertaken?
70% of clearance work has been done. Now the construction will come, my lord. And
No.
vacation order,
Kindly on report, Mala, the deputy commissioner's report I am indicating, kindly come to paragraph 16, para number 16 at page 5. I have placed the report of the deputy commissioner, Mala. Para 16.
Yes.
As per report of the executive engineer PWD Soraideo District Territorial RD Division Sonari, the petitioner has wrongly stated that the construction and widening of the road has yet not started. The up-to-date progress of construction and widening of the Naharali under Assam Mala road is 79% and more than 36-kilometer road has been widened from 3.75 meter to 7.00 meter carriage away.
Now come below that.
Yes, Mala, at the town portion of Bojosareli, drain works are going on. Widening of road is only possible after completion of drain work. So Mala, we have to do here, the original date of completion is 25/8/23 and now the completion time is extended till 26/7/2024.
So who is given in the time?
Well,
If your original date of completion was 25/8/2023.
Yes, Lord.
Who has extended the time?
PWD has extended because
So you have extended the time.
Yes.
Is it because the petitioner did not vacate the premises alone? Is that the only ground?
No, only my lord, so far as this part is concerned, my lord, now only this particular building is to be cleared, my lord.
We are asking you something. See, your original date of completion,
The
including
comment is limited to the amendment made in the requisition.
no,
If new queries
we are not concerned with the comments coming from the department. These are actually not meant for us. These are meant for you.
Fine.
We want to know from the council that if the original date of completion was 25/8/2023
extended by the PWD.
by the PWD, is it only for obstruction of this particular building?
That specific I can have it, madam. The two madam I can have it.
And madam,
Because madam, doctor will see.
So therefore, we suggested that you give them a fixed time,
but
allow them to vacate.
Annexure A, the next page in my report, Malad, Annexure A, this is 14/8/2023, it was issued to bank.
vacation notice, your lordship will find, this is the ultimate. Last page, annexure 59. It was issued only 6th of June. That is the first communication to us. Earlier communications, forget about, we took time and we searched for the land. Thereafter, all notices were given to the landlady and she never told us that she got the compensation.
There
Then
is a notice here,
59.
addressed to the bank.
No, page 59, lordship.
There is a notice he has enclosed, which
Yes.
is addressed to the bank, which was issued on 14/8/2023.
Then subsequent.
That was not at the, that was the initial stage. Thereafter, we searched for the premise. Ultimately, the vacation notice here, lordship, page 59. They waited to issue this vacation notice till 6/6, page 59, man. This is the first reply we have got.
Next one also, kindly see 5/9/23.
So that is what we wanted to know. So if your contract period is going to expire, why did you wait for this end of the period to get the process vacated?
Well, the person concerned has already received the landowner, he has already got the amount. Now
Then why did you issue a notice to the bank?
Well, they are not going, vacating the place, Malad.
Therefore, that's what we are asking you.
Malad, the land is,
If you want to, if you want
now
to,
there is no landowner.
no, Mr. Garment, then let us issue notice. We'll hear the matter on merits.
No, lordship,
We'll hear the matter. You file your affidavits in the matter.
Malad, Lordship, from PWD side, they say that they can.
We want to know, we want to pass an order for closure of the matter. If you're insisting that no, it has to be done within 30 days before the extension, then we'll have to hear the matter to give an order whether they're entitled to any relief from this court. That's all. If you're ready to argue, we can take it up now.
But 2 months time from our side, we are expressing a difficulty that the work will be hard. We are expressing that.
We
Because-
gave you liberty to examine their premises and give an assessment to us. What for did we give you liberty?
It is difficult on our part.
Why?
That the circle officer, how they will go and assessment will be done. Now, kindly see, the owner has got the amount. There is no land owner. Ultimately, the premises belongs to the authority because the government, they are.
Therefore, let us hear the matter. We'll hear the matter and dispose it off.
Lordship, kindly take it up at 2.
Not at 2. We'll take up the matter today. You want to file any reply or you want to rely on the instructions that you have placed before the court?
The instructions I have, that is,
Sufficient.
that is what I.
Very well, then we'll take it up, Mr. Borbora. We'll take it up today. You want it in the second half?
In the second.
All right.
Well, at 2, my lord.
May it please the Lordship. The Lordship, the petitioners are aggrieved by a corrigendum that modified serial number 18 of the state OBC list, Your
Yes.
Lordship.
I need some time to get my exception.
Further time.
Lordship, notice may be issued.
Let him get instructions, let us see. Matter be listed after 4 weeks, enabling the respondent counsel to obtain their instruction. MS so-and-so appears for the writ petition. Yes.
Please, Your Lordship, I'm mentioning on behalf of SB Chaudhary, Lordship. She's on legs in court number 10. This matter may be taken up after some time, Lordship.
Yes, any instructions?
Yes, Malot, I have received the instruction.
All right. After why?
Deeply obliged. Last occasion, Lordship asked for the status of pending representations, my lord. One set of instructions we have received today, my lord. Circle officer has responded to the court order, my lord. As per his reply,
No, what is the prayer here? He has filed some representation.
Presentation.
It could not be traced out.
but after, on the receipt of this notice, my lord, court notice, copy of the notice, he has verified the record and accordingly placed some instruction before your lordship, my lord. So that representation was not received by his officer, it is not placed up by
Then you bring it on record.
my lord.
Bring it on record. File your affidavit.
My lord. And in that
Third
case,
learned counsel,
notice has to be issued. my lord.
issue notice, returnable 4 weeks. MS M. Bormon, learned family advocate, will obtain complete instructions and file necessary affidavit in the meantime. List after 4 weeks.
My
Obliged.
Any instruction?
Yes, my lord, as per the instruction received, my lord, the complainant submitted his FIR complaint before the OC of Warsaw Police Station instead of Bosista Police Station. My lord. That is why it was sent back to the police station, Bosista Police Station, and petitioner was also in
So what has happened now?
that part, the instruction that was furnished on 20th July. Oh, sorry, 20th June, my lord. That is the instruction we have received. Because he has to co-part, my lord, petitioner, because petitioner was also requested to communicate with the, my lord, the OC, Bosista Police Station.
All right, none appears for the writ petitioner and the matter is called. Mr. B. Goswami, learned petitioner lately assisted by Mr. Kakoti.
I'm in 28, my lord.
This is your matter?
Yes, yes.
Okay. Yes. It has been transferred to the appropriate police station. That's the instructions received.
Which police station, my lord?
Bosista.
Bosista. And the petitioner has been informed.
Yes.
Is there any notice available?
That is the expert police Bosista. Well, জানাইছি তো। ঠিকানা জানাইছি, আপনাকে তো যাব লাগবে না। মানে রেকর্ড করে
Even the Gorchuk police station also the jurisdictions, my lord, in this matter.
Sorry?
Gorchuk police station has also the jurisdiction in the matter, my lord.
Doesn't matter. It's the authority who decides. If it is Basista, then let it go to Basista.
This is in Kamrup district, na?
Maybe. But the jurisdiction of the police station is for the purpose of investigation of the matter. কামৰূপৰ কোনেও নকৰে না ইনভেষ্টিগেট আয়োগটো থাকিব লাগিব অচি পুলিচ ষ্টেচন ৱাইজ জুৰিডিকশ্যন
What is the name of the petitioner?
Shashi Prakash Rai.
When was this sent?
It was sent on
No.
Yes, I have treated the complaint as 0 FI and send it to the OC Bosista Police Station for internal action by GT number 13 dated 20424.
Now, what is the status of this investigation?
But that part, my lord, that is why, my lord, he was requested, the petitioner was requested by the Gorsu Police Station to take up the matter with the concerned OC of the.
What is there to be taken up? When FIR has been filed,
My lord, after all, the statement has to be recorded.
so
That part, my lord, at least petitioner has to submit with your lordship.
no, but this information you have received from Gorsu. This information you have received from Gorsu. What is the status in Bosista?
Yes.
You have to
part,
get it
of
from
course.
Bosista.
That part we have.
Yes, you get the instructions then.
Yes, but the petitioner has also responsibility, my lord.
But whether he is gone or not, you find
Yes.
out from Bosista.
Yes, we'll do that.
How much time do you require?
7 days?
It has to go in July. Let it come in July. Or you find out on it will just take 1 day's time.
it could
Let
be,
it be
minus day after tomorrow, minus
day after tomorrow you find out what is the status. Heard learned counsel for the parties. It is submitted by the learned government advocate that The FIR which was lodged by the petitioner in the Gorsuk police station has been transferred to the jurisdictional police station, which is Bohista police station, by treating the same to be a zero FIR and by the GD entry number 13 dated 2004-2024. The learned government advocate is permitted to obtain instructions in respect of the steps undertaken in respect of the investigation, if any, pursuant to the FIR received from the Gorsuk police station. Let the instructions be placed before this court on the next date fixed, which is on 26th. Let it be on 27th.
My lord.
27th.
At least 20, huh? 20. Can it be on 28?
All right, 28th.
My lord.
Mr. Rai, yes. Any reply?
We haven't filed a reply, my lord. There was an interim direction to provide him an electricity connection. That we've done. Premises have been energized now.
It is submitted by the learned government advocate that by the advocate for APDCL that petitioner has been provided with electricity connection.
In terms of the last order, my lord.
In terms of the order dated so and so passed in this court. Accordingly, matter be listed after vacation on a date to be fixed by the regulator. Yes. Yes.
And except for the
While receiving the copy, if these things are being indicated, then for.
No, on the last date, I have informed before Justice Kaushik Goswami. Yes. On the
It was
last
listed
date.
before you all.
Yes, sir.
You
We'll give it, we'll give it.
copies. Learned counsel, copies of the pleadings, including that of the annexures. Both the writ petitions are similar. You have to
More
file-
or less similar.
More or less same.
Now you are filing your counter here in one or both?
In both.
In both.
In both, because the prayer are different.
Have you filed in item 30?
And no, because it is interrelated. I have to peruse the annexure.
It is submitted that since the complete set of pleadings have not been served in the respondent in item number 31, particularly case number 2, the say as the matters are interlinked, the affidavit would not be filed. The respondent will furnish the pleadings within the course of the week. And thereafter, the petitioners will furnish the pleadings along with complete annexures within the course of the week. Thereafter, the respondents will file their annexure.
My lord, can it be on 25th of July, my lord? A fixed date because.
26th of July.
26th.
List on 26th.
The number.
None appears. Passed over.
In this case, I'm agreeing for the respondent. If affidavit is there, I'm filing today itself. With oversight, it was.
Mr. RS, Mr. IPS Commissioner, Mr. FCKL submits that the affidavit, the matter is being filed today. Let the matter be listed in the month of July. On 2nd of August, by which time rejoinder affidavit, if any, may be filed.
It is interim order. Interim order is there.
Interim order passed earlier will continue to the next date of it.
Oblige, your lord.
Mr. KL, in the earlier matter, we fixed it day after.
No.
So we'll have it on 27.
Income tax matter.
Income.
No.
Please inform the council to the.
No, I'll.
Item 32, my lord. But earlier similar matter has already been disposed. Lordship may can dispose it of also in view of that line. On the basis of the judgment. My lord. Disposal means, my lord, the petitioner was literally dismissed, but one observation was there.
Hey, Samik. Yes.
Against the demand of establishment charges. So certain the
Who's the
direction.
respondent now?
Respondent, my lord, Mr. KP Pathak used to appear. My lord.
Please call him. If you have to dispose it of, it must be done in the presence of council. Please call him. Thirty-two to Matiti.
34. May I please, your lord. Lordship, the matter has been disposed of by order dated 11/4/2023 by the Honorable Division Bench, my lord. Yet the petitioner had preferred and writ appeal before the Honorable Division Bench.
Against this last order.
My lord, 11/4, by an order dated 11/4 by the Honorable Division Bench.
No. Which order did you prefer?
My lord, the last non-granting of interim order.
That is 2-0.
My lord, 201. 2012, 2022, my lord. The last page. my lord.
Writ petition is also disposed of.
My lord, why sure that.
Okay. It is submitted by the learned counsel to the petitioner that ID
11/4.
order dated 11/4/2023 passed in writ appeal 78 of 2023. The writ appeal preferred by the present writ petitioner against the order dated 20/12/2022 passed in the present writ petition has been allowed by the said order, the writ appeal 78 of 2023 as well as writ petition 7950 of 2022 within bracket, namely the present writ petition, were allowed by the division bench. Stop. In that view of the matter, no further order is called for. Writ petition stands disposed of in terms as writ petition is allowed and disposed of in terms of order dated 11/4/2023 passed in writ appeal 78.
Deeply.
May I please, your lord. Herein, page 18, your lordship, by this order, the construction of the page 18, your lordship. The building construction of the petitioner has been stopped, your lordship.
Yes.
The petitioner had started his artificial building construction after receiving building permission from the concerned authority. And
The petitioner have already completed the foundation of the said building. In the meantime, on 22/5/2023, this letter has been issued. Case 18, Your Lordship. Case 18.
Who's for the respondent department?
This matter was represented the municipal board. We are not taking notice on their.
You have to array the concerned department.
My lord.
You
They have
file an application.
Only
The
municipal.
concern, what is that department?
In the causation, Your Lordship.
Yes.
DA has shown for respondent number 2, my lord, but municipal board, they have chairman elected members, my lord. So we are not taking notice on their
Executive member is represented by
executive officer.
executive officer.
Lordship,
The causation, one as Barua, Your Lordship, has been shown.
my term, but copy is not
And
served to us.
the
my
copy
lord.
has already been served.
Then I have to ask him.
In this regard,
Yes, there is an order where S. Purva
My lord, I.
represents number 2. Call Mr. S. Purva
My lord.
after a while.
At 2, Your Lordship.
After a while, as and when he comes, we'll call up. Huh? Thank you.
My lord, instruction was sought, my lord.
My lord, in this matter, my lord, pursuant to a sale notice, my lord, the petitioner made an offer, which was accepted, my lord. The offer was around 3.18 crore. Thereafter, my lord, the petitioner made a partial payment, and the remaining amount was paid by 2 different persons. So subsequently, my lord, they made a request that the registration process ought to be done in some name of the firm, which was refused. But subsequently, my lord, the petitioner now has made a request that the registration process can be done in his own name. I mean, we do not have problem if the registration is done in his name.
We
If your lordship will kindly see the prayer.
My lord, since the
Prayer
payment has already been made, all the formalities have been completed. Only it's a part of
No,
registration, madam.
who has no objection?
But AIDC.
AIDC,
Yes.
bring it on record.
Yes.
You
If your
bring it on record.
Yes, if your lordship will kindly see the prayer portion, madam.
Prayer at page 15.
Prayer page 15.
To initiate the process of registration of the purchased property.
No, we understand. The AIDC does not have an objection if it is registered in
Yeah.
your name.
Yes.
We want that on an affidavit.
Yes.
Bring it on record.
Yes.
Third, learned counsel for the parties, the counsel for AIDC submits that if the property which has been purchased by the petitioner is registered in his name, there is no objection as the sale certificate. There is no objection by the AIDC as the sale certificate was issued in its name.
Yeah.
The learned counsel representing the AIDC is permitted 2 weeks' time to file the necessary affidavit to bring on record the instructions received. Mr.
N. Kalita.
N. Kalita for respondent 1. Appears for respondent 1. List after 2 weeks. MS N. P. Chaudhary for the writ petitioner.
Hello.
Matter related to the appointment of arbitration, my lord.
May I please report? Lordship, I am appearing for the respondent number 1 and 2. Lordship, affidavit has not been filed by us, Lordship. Time may be allowed for filing it.
Yes.
Appointment of simple, my lord, arbitration.
Very well. Third learned counsel for parties. MS, your name please?
G-Tech,
GTech IPS for respondent number
1 and 2.
1 and 2. She prayed for some time to file affidavit on their behalf and bring it on record. Matter be posted after 2 weeks, enabling the respondents to file their affidavit. After 2 weeks.
Lordship, in this case, we have filed an affidavit, Lordship, but since the one para that is required to be inserted line defective, I'll rectify by tomorrow. Let it come day after tomorrow.
Yes, day after tomorrow. Then at CGC, you're for CGC. Mr. P. Chakraborty submits that the affidavit can be brought on record after clearance of defect. He submits the matter be listed day after. Mr. GD Dhiman, learned a petitioner in person, does not object to the prayer made this day after tomorrow. Let it be on Thursday. Thursday, based on 27.
41.
And appears for the petitioner on call. Mr. G. Hendrick appears for the respondent. All.
No, Lordship, I appear on behalf of respondent number 1, 4, and 5.
1, 4, and 5. Matter be listed after in the month of July on a date to be filed by fixed by the registry.
My matters are fixed on 22nd of July, my lord, regarding force measure, my lord. This, my lord, 42, 43, and 44 taken up on 2nd of July, my lord, 22nd of July, my lord.
We'll hear these matters.
My lord, yes. Government has given some relief, perhaps now maximum will become infrastructure. In GST,
Last three council meeting, they have recommended some relaxation. Some relaxation to the SCC law. Okay, some of the case will fall under that relaxation.
When are the other matters fixed?
22nd of July, my lord.
All right, heard in part. These matters be listed on 22nd of July, along with other similarly situated matters. The Learned Standing Council, GST, as well as State GST.
My lord.
Submits that GST Council has passed some orders.
Some recommendations have been made.
Some orders, some recommendation which he submits will be placed before the court on the next date.
My lord.
List these 3 matters along with all other connected matters on 22nd of July.
Deeply obliged, my lord.
Up to 44 law.
Yes. Yes, we have dismissed.
For item number 41.
Your counsel, I don't know if advisory council is there. Yes.
But it pays 47, my lord. A small amount was sanctioned, my lord. My house got, my lord, burnt, my lord, fully. And under disaster.
Mr. Hendrick,
department is, my lord.
counsel for petitioner is here.
Is 47.
Item
41.
Any instructions here?
No, Lordship, I need some time, Lord.
Matter be listed in the month of July, on 29th July, by which time the respondent will obtain the required instruction. Mr. AFN.
AFNU Mullah.
AFNU Mullah, the case of the writ petition.
Obliged, my lord.
PC required.
Item 46.
Instructions are awaited in this matter, my lord. Pray for some time to file our.
Instructions awaited.
My lord.
Okay. counsel appearing for the respondents submit that instructions in these matters repeated. He therefore submits that the further time be granted to it. He prays for 3 weeks further time. Mr.
P. Das, Lord.
P. Das appears for the.
The Argent Council is online, Lord.
Yes,
Lord.
Mr. Counsel. The respondents are prayed for further time.
That's fine, absolutely fine, Lord. Just wanted to appraise the Honorable Court that day before yesterday, GST Council has held its meeting, whereby my case has been affirmed in the crystal clear form. So a limited time can be given to the respondents. That's fine. My interim protection can be extended.
What has been affirmed? What has been affirmed?
My lord, the case has been made by the department, whereby they said there is a violation of 16(4). GST Council from its side has said that no ITC shall be disallowed for year 17-18, 18-19, 20-21 if the ITC has been availed by 30th November 2021. Whereas my case is
why don't you bring it on record?
My lord, because we got the documents press release only on yesterday. That is why I could
Very
not.
well. You also bring it on record.
Sure, absolutely, I will do that.
Learned counsel appearing for the petitioner submits that the GST Council has recommended. You are submitting that the council has recommended.
Yes, my lord. GST Council in its 53rd GST Council meeting held on day before yesterday
has recommended the case of the writ petitioner. It's received the communication. He'd like to bring it on record in the meantime. Let the respondents also file their counter, if so advised in the meantime. List on 29th
29th of
July.
Fine, lord. Absolutely fine.
29 July. Interim order passed early. Will continue till the next day. Next.
Deeply
Yes,
obliged.
Item 47.
By your lordships order 24/5, your lordships has directed us to file an affidavit regarding the verification, the field verification. But we have received that field verification report. But we have not yet filed our affidavit. May I place that?
No, bring it on record.
But even then, lordship, I am praying for some more time, as because in the field verification report, they have not mentioned whether that their land is acquired or not, whether it is used or not, as because that is the most vital part, Lord.
Mr. H. Sharma, learned additional senior government advocate, prays for further time to complete his instructions and setting affidavit in terms of the order dated 24/5/24. Learned counsel appearing to the petitioner does not prayer made. List this matter again in the month of August.
Lordship, that will be better, Lord. I will bring that.
August. 5th of August.
Lordship.
5th.
Okay.
On an earlier occasion, Honorable got directed to produce the record regarding the disbursement of the amount value.
Yes.
क्या दिला ये
Hardly legible.
That is minus 6,36,650, that bottom part. 636,665.
Yes.
And the second is Madam Salar.
Huh?
Second, case number 7, second is Madam. That is Salar, 5,78,000.
and another is case number 3258, total 65.
Yes, Mr. Deka.
My lord, it is there, the deposited before the deputy commissioner,
Yes, we are deposited before
but deputy
deputy commissioner.
commissioner, my lord, denied, no such amount has been deposited in the account, my lord, affidavit. My mission, my lord, my case is, my lord, it is not a case of acquisition, my lord. Lordship, kindly, I like to draw your lordship, my lord, kind attention, my lord. One order passed by the Honorable Court on 5/1/24, paragraph 4, my lord. And then I like to take your lordship, what is my prayer in this petition? 5/1/24, my lord. A specific prayer I will draw your lordship kind attention at.
Yes.
Yes, my lord. In this writ petition, the petitioner with the above facts have contended that during the period within which the parcels of land were under requisition from 1906-2004 onwards, the petitioners had received the last requisition ran, my lord, kindly noted, my lord. Requisition ran only on 5/8/2005, and the memo disbursing requisition rent did not also disclose the period. The subsequent to 5/8/2005, the petitioners, that's the last order. The petitioners did not receive any requisition rent till date. This honorable court is recorded, my lord. Our case is whether not acquisition method. It's a rent. From the above conspectus of facts, it appears prima facie that the parcels of land of the petitioner mentioned above have not been acquired by following any valid process of acquisition, my lord. Already this honorable court has held that there is no valid process of acquisition as the respondents till date have not brought anything on record as regards the culmination of the land acquisition process initiated by LAK 6/2023 under the Land Acquisition Act 1894. Since the amount of so-and-so stated to have been deposited by the respondent authorities in the Union of India, and the said amount has not been disbursed by the Deputy Commissioner CASA, the petitioner till date, it is not possible for this court at this stage to arrive at any final opinion. Though, my lord, the initial, though they have the registered one LA case, my lord, the acquisition case, my lord, but this honorable court is specifically recorded, my lord, that acquisition process is has not been acquired any following any valid process of acquisition. That means, my lord, like now, like lordship, kindly have a look on my prayer. What is my prayer in the petition? At page, my lord, 16. Page 16, my lord. My first prayer, our first prayer, my lord, at 1:16, my lord.
Handing over vacant position.
First prayer, handing over our position. Next, second is, my lord, directing the respondent in order to pay all the outstanding rent, my lord. Outstanding rent, which has been accrued over these years of censure. That means 2000.
Prima facie, all right. Prayer number 1 can be allowed, but
Yes.
prayer 2, you have to file a proper suit.
My lord, in this case, what happened, my lord? Though affidavit responded by all the respondent concerned regarding, my lord,
who has acquired this land?
My lord, initially, my lord, in Union of India, my lord, and in the 2014.
Who is in occupation of the land?
I'm the owner. My father was the landlord, also the owner of the land.
Now,
for the purpose of, my lord, for the purpose of the, my lord, the established ACO headquarter BSF, they acquired our land in that 1964, 65, my lord. Then that's in 64, 65, they paid us rent, my lord. Since 2005 onwards, my lord, 5/8/2005 till date, we have been receiving rent. But thereafter, they stopped paying the rent. But in the meantime, my lord, in the 2014, this Union of India has handed over our land to the PWD, my lord. Since 2014, my lord, the PWD till date, they are enjoying our land, not even single payment made. But affidavit filed by the PWD, not even single whisper made so far as that.
The BSF has vacated the premises.
Yes, they have handed over to PWD, 2014. My lord, since 2005 to till date, not even single rent has been paid to us, my lord. Here, my lord, one affidavit, my lord, they have said that 6,36,000 is the outstanding dues of the land acquisition, whereas land acquisition case is already declared by the Sunil said invalid, my lord. So my humble subject in this case, perhaps, my lord,
where has it been declared invalid?
My lord, already in paragraph 4 of the order passed by the Honorable Court, my lord, at paragraph 4. It appears prima facie that the parcels of land of the petitioner mentioned above have been acquired by following so any valid process of acquisition, as the respondent till date have not brought anything on record as regard the culmination of the land acquisition process initiated by Chenzo. Since the authority, my lord, the process initiated the land acquisition get no records produced, my lord, no records placed, my lord. Since 2005 onwards, my lord, we are not even single payment rent has been paid to us, and we're not even not vacating the land. And even, my lord, one letter, additional deputy commissioner made, lordship, I have enclosed in the petition, page 28, annexure 7, my lord. Page 28, annexure 7.
Yet.
This letter dated 4 August 2014 by the additional deputy commissioner to the officers commanding with reference to the subject caption above. I'm to
All right,
inform
then
Ye-
we'll hear
yes,
the matter.
that means specific matter, since the National Highway Barak Valley have been handed over to the State Public PWD Works Department. I
Who is for
request
the PWD?
Yes.
What do you submit?
We have to know affidavit.
Hmm. You have deposited the amount to the DC,
No, we have not, Lordship.
the BSF.
India has deposited.
So why is the land under your occupation now?
That part, Lordship, I have to take instruction, but our affidavit says that at that point of time, the while handing over the land had not been mentioned anything about the pattadars or payment of any rent to them. So this division
No,
is
but
quite,
why was the land handed over to PWD?
Yes.
yes.
PWD is not the authority under whom the vacant land, government land is to be looked after. It is by the revenue department.
Yes,
So why was it handed over to the PWD?
that part I have to take instruction.
Your
because
affidavit-
Affidavit is.
My affidavit is
not
absolutely silent on this point, sir.
Then
decided.
we'll keep the matter for hearing. If you can get your instructions, you get it. Otherwise, we'll pass order.
My lord,
Lordship,
one specific query necessary in this case, my lord.
Admit, heard Land Council admit, matter be listed for hearing the month of August. On a date to be fixed by the registry. Yes.
My lord, in this first, our case is specific case is the non-payment of rent, my lord. So my learned.
Firstly,
senior-
they have to be, in legal occupation. Only then there's a question of rent.
My lord,
You may choose to pursue against them for compensation. That's a different issue. But if you want to demand rent, unpaid rent,
well, it is they are also admission they are on their part also that they're paying rent to us, my lord. That is also there, my lord.
no, but is there an agreement executed?
That is it is partly it is in their record, my lord. Since 2064 to 2005, we are getting rent, my lord. Thereafter, they stopped to pay any rent to.
From whom did you get rent?
My not from Union of India.
Union of India.
And yet,
So
thereafter,
Union of
my
India
lord,
left.
suddenly they handed over this land to PWD even without informing.
Now you're asking rent from whom?
My lord, Union as well as State Board. So for my rent is concerned, some observation made so that they could on next occasion they could brought. My lord.
So we'll hear the matter finally in August. Because this will have to be decided whether their occupation is correct or incorrect as per
Lordship, then I humbly submit, Lordship permits me, then one additional affidavit necessary to bring exactly what at present stage and our prayers, my lord. That may be granted, my lord.
Who will file it?
I file one additional affidavit, my lord. Can you allow us to file affidavit, additional affidavit?
You file it.
Yes, my lord.
You do one thing, you let the matter be listed.
Yes.
And then you make a prayer. If required, you file it. We'll grant you permission.
My lord.
Not otherwise.
My lord.
We have admitted, then matter will be heard.
I think the lordship, this says lordship kindly notice may be given to file our additional affidavit, your lordship.
That provision, your lordship directed them to bring their policy.
On that ground, lordship, kindly contents may be given. We'll file our.
You have been given 3 weeks time. What have you been doing for last 3 weeks? We have granted you 3 weeks time.
Lordship, but we have not received the list of the
of the petitioner's name, Lord.
Then?
Can you sometimes may be given out? We'll file our affidavit after vacation, your Lord. Immediately after vacation, Lord.
All right, list on list on 15th
Okay.
July.
Lord.
Respondents are permitted further time to file their additional affidavit. Right. Mr. J. Ahmed appears to the
As a last of.
15 July.
Lord. I'm obliged, your Lord.
May, Your Honor.
Yes.
And what we have directed the DMDA to file its affidavit, affidavit sent for vetting.
Affidavit by
DMDA.
Huh?
GMDA.
DMD.
It will send for vetting, Lordship will fix it immediately after the opening, Madam.
So, PM,
I'll leave it to your Lordship, ma'am.
Sir, has Bora setting up DMC or DMDA?
Both, my lord, but DMD is affidavit with 5 and 6, madam.
Respondent 5 and 6. Okay, that the affidavit will be filed for the time. Submit the matter be listed immediately after reopening, by which time he will he will endeavor to find the affidavit. Mr. A.K. Mia, the counsel, made, and it's going to appear for
Lordship, I appear for respondent number 1 to 4, CGC.
let the matter be listed on
24 July, my lord. If
23rd,
24, my lord.
24th. All right, 24th July.
Obliged.
May I please, Your Worship? My lord, for the first time today, I have engaged in this matter, my lord. If Your Lordship kindly give me some time, my lord. Just want to go.
The RAM not is for the respondent.
No, my lord, petitioner
You're for the petitioner.
for the petition.
Submits that he has been recently engaged in the matter. He prays for submits that the matter be listed after reopening. List according to your.
My-
29?
Yes, Your Lordship.
29.
My lord, there is an interim order, my lord. To 10, 6, 20.
So interim order.
Yes.
That will- All right, interim order will continue till 29.
Obliged.
That's it.
Last time, my lord, time was taken by the respondent to take the decision on my application.
Lordship, the decision is still in processing, Lordship, and they need some more time. Praying for some time, fixed date after vacation, Lord.
So much.
Respondent counsels pray for further time. Submit their instructions by the header. List again after reopening.
19.
19 July.
Okay.
Yes.
Letter regarding my lord, establishment reclaim in a agricultural area, my lord. The last applicant, my lord, well has filed a my lord affidavit. Last applicant, my lord, government has took time for filing affidavit. So in this case, my lord, the direction is there because before passing the impugn order, my lord, there is a direction for the division bench that certain directions should be followed before passing the order. But that direction has been not been followed. And accordingly, the impugn order passed from 19 to 2024. And direction was this, my lord, to take a report from the agriculture officer, agriculture department, and my lord, pollution control board, and also for my lord, DT officer. Without taking any, my lord, report, my lord, that order has been passed. This order has been passed on the basis of that order. I have nothing to say. Can you see, my lord?
Now, who is to file an affidavit?
That, my lord, it will be filed by Pollution Control Board and my government.
Yes, government and pollution control, who's the pin? Mr. Sharma,
I am for this respond number 3 and 4, Deputy Commissioner Lordship. Yes, Lordship, we have not yet received any instructions.
who is for pollution control?
Pollution নাম দেখাইছে না
Purva is here, my lord. And Purva is here, last appeal.
নাম দেখাইছে না
Agriculture, anything to fight?
Instruction is clear.
I appear for the private respondent. I have filed my
Pollution, my lord. The only thing, my lord, lordship is, my lord, but pollution has, my lord, issued a consent to operate only for 3 months. And it was issued on 21/3/2024, and it was expired, my lord. On my humble prayer before your lordship, my lord, till the, my lord, this petition is disposed of, my lord, no further, my lord, consent to operate to be issued, my lord. Because this, no further consent to operate to be, my lord, issued. Because, my lord, because only consent to operate only for 3 months. That 3 months has already been expired, and that was reflected in the order, my lord. First order, it is 8/4/2024. And my lord, this dispute is going on since 2012, my lord. And the second round of litigation, my lord. Only this time, my lord, because of that order, my lord, this consent to operate has been issued, my lord. So, till the disposal of the deed petition, my lord, no further, my lord, consent to operate will be issued, my lord. So we are the, my lord, poor people, my lord, our whole people, because of this big clean, my lord, entire, my lord, petty has been, my lord, damaged, my lord, because of rising of temperature, other thing also was there, my lord. And 2012, since 2012, my lord, when the first decision filed, my lord, till then, my lord, no, my lord, consent of operation has been issued, my lord.
What has happened to the consent?
Yeah, but the consent of
Is it operating now?
it was given for 3 months, Lordship, initially. Now, on the part of the stay, Lordship, I had filed a caveat. It was hard at length, and stay was not granted because every direction of the division bench had been followed. Lordship may see the impugned order. All parties were heard. The
We
pollution.
are asking you whether NOC consent has been granted or not.
Yes, granted, but only for 3 months, which has
That's right.
expired now.
Subsequently, it has not been renewed.
Not been renewed because now we have applied again. And now it is not operating because of the season. Lordship, it operates only on dry season. Now it's flood. And before the next season, this matter can be heard. Lordship, pleadings have been filed. Therefore, it can be finally heard.
Pleadings filed by only you, not by the other respondents. Are you filing any affidavit?
No, Lordship, we have not yet received any instruction.
And what about government?
Well, government, Lordship, I am.
Who's for the pollution control? H. Sharma, Regional City Advocate, representing. Three and four only.
Lordship, 3 and
Ms. B. Bora for five.
I am for 1.
Emmett, M. Colita for 1, 2, 6 and 7. None appears for pollution control board. 9, 8, 9, 10. Mr. Bora appears for respondent 12 for the 25. The other respondents are permitted to matter be posted immediately after reopening of the vacations on a date to be fixed by the registry.
Only when that concept or issue, my lord, that not to kill that issue, my lord. But since 2012, my lord, and this.
It was hard, Lord.
No, that is it. 2012 is not an issue, my lord. I stated in all my petitions.
And
Since 2012, my lord.
Submitted that the consent
To operate.
Consent to operate was issued by the
Pollution
by the
control.
Pollution Control Board. When was it issued?
On 21/3/2024.
2024.
Only for 3 months.
The same has been expired. The respondents, more particularly Pollution Control Board, will not
Previous
attempt
right.
to renew the consent to operate without the report. Yes, what do you have to say? Do you have instructions?
No, lots of.
File, get your instructions, file up. List in after reopening on a date to be fixed.
Lordship, on a last occasion, this prayer was denied by the coordinated bench. Because of the same prayer was made, but this prayer was denied.
Yeah, we are granting it. You are free to go and appeal. We are not stopping it. We are saying not to grant without leave of court. That's all. If the Pollution Control Board has proceeded, they will intimate the court. On that date, if we feel that yes, it can be extended, it will be extended.
But these petitioners have no locus. We have filed our detailed affidavit.
We hear it, but your as on date, your brick kiln is not operating. Isn't it?
Not operating.
Then how are you affected otherwise?
We may apply for the.
You may apply, you apply, and then you inform the court.
Lordship, the petitioner herein is aggrieved by the fact, your lordship, that an illegal construction violating all the municipal norms has been carried out adjacent to his house, your lordship. He has filed several complaints, your lordship, before the Tezpur Municipal Board. Your lordship,
How do you know that the norms have been violated?
Your lordship, I have stated in my complaint as well as I have furnished some photograph as annexure 1, your lordship. There was hardly any space, your lordship. Your lordship, the terrace of
What is the requirement under the law?
Your lordship, at least 1.5 meter of distance has to be maintained, your lordship, from the boundary
Where
wall.
is your representation?
Your lordship will find my representation. Annexure 1 is the photographs, your lordship. From annexure 2, your lordship, is the first, is the representation page 16, your lordship. Your lordship, thereafter, I have again filed representation before the district commissioner. Then thereafter also I have filed, your lordship. I have sent a legal notice to the chairman, Tezpur Municipal Board.
A handicap is for
1 to 4, lordship.
1, 3, 4. Steps of response 5 and 6. I report the extra post. Extra copies be furnished to Mr. Reddy within the course of this week. And might have been instead after.
Your lordship, since the construction is going at a brisk pace, your lordship, some interim protection may be given, some interim direction. Your lordship, at least a survey and inquiry may be done, your lordship. And
have you served advance copies on the Tezpur municipality?
Lordship.
Have you served copies on the Tezpur municipality?
This writ petition.
Yes.
No.
Then you should have served copies.
Your lordship, before filing the writ petition, your lordship, we have filed the necessary copies. Your
on whom? Is there a standing council?
Tezpur Municipal Board. Urban.
Then without hearing them, how can we grant your interim order? Stopping somebody else's construction. You should have served copies on the private respondent.
Your lordship, a date may be fixed.
You take steps first and make a mention.
Okay, good.
Item 13.
Yes.
May I please, as your lordship? My lord, basically, the petitioner is aggrieved with an impugn notice of demarcation, my lord, is at page 60. This one.
Lordship, may I explain one thing, my lord, that GMC, they made a party GMC. Lordship, their name not reflect in the, my lord, that code. So
It may not be reflected, what can be done?
Whether the copy has been served to the GMC or not.
Have you served copy?
As a party, my lord, without service nowadays. Otherwise, my lord, their name may be shown in the copies. My lord can fix it on, my lord, on Wednesday or tomorrow, my lord, by showing their name.
Why don't you inform the GMC council if he is available?
My lord,
Thursday, we'll take it up on Thursday.
my lord.
It's on Thursday, registry to reveal the name of the GMC council. As it's submitted that count, name of the GMC council is not reflected.
My
Mr. Huya will serve extra copy.
Extra copy.
Standing. Please,
Bless you.
Thursday,
27.
27.
27. Apply.
Item number 32.
Yes, Mr. Golden.
My lord, the excise departments and the demanded, my lord, establishments are.
Who's
taking
appearing
this
for
petition.
excise?
I'm
Yes,
appearing.
Father. You are appearing.
What series of
He is presented an order
Lord,
to coordinate bench.
yes, sir.
He wants a disposal in similar term. Have you gone through these orders?
Yes. Paragraph 25, man. Last page. Observation and inquiry.
Okay. But
Obligement.
35.
Lordship, in item 35, your lordship, in.
yes, you are representing number 2.
Yes, executive.
Yes, please get the instructions here. Because the respondent 1 is not represented.
Oh, yes, one hasn't been represented. So ultimately, it is the municipality board. So they don't have a standing council. Ultimately, this executive officer has been communicated. So the instruction is still awaited.
You have communicated. Mr. A.M. Khan for the petitioner, Mr. S. Bodua hearing for respondent. Submits that instructions are awaited. We continue. That will be listed. Month of August. 2nd August.
Lordship, date, your lordship. Second,
2nd August.
it will be too long, your lordship.
Why?
Because my construction, your lordship, materials here, construction has been stopped, your lordship, therefore. Only.
All right, 26 July.
All right.
26.
21.
Doctor, is a DNR made in the midst of a hearing in court number 15, Doctor?
We had fixed it in his presence. He had agreed to be available in the matter. Yes, so
In court number 15, matter is going on, Lordship.
what can be done? We can't wait for him.
Lordship, damage that otherwise, my lord, the instructions has already been placed before this honorable court. My lord, if we go by the instructions, my lord, that part and parcel of the land, my lord, that has already been acquired and PWD has already, my lord, taken possession. Now, my lord, they are acting on a lease deed, on a strength of a lease deed. Let them, my lord.
No, very well, yes. You can start. You can start, Mr. Borpura.
All said and done about, after hearing the my lord, that something is going to happen, we initially 2013 my lord, and they are harping on this, that 1 year ago they sought for time. Sought for time, meanwhile we search for the alternate emission. Now, and it is in the process of shifting my lord on war footing. Alternate premises there. And but kindly see all along that landlady was have never communicated us that he has already got the compensation and all this. Still, my lord, page 53, your lordship will find it was notice of April 22, page 53. It's in SME, I have given the translation.
Yeah.
It has been given to the landlady. So, for the first time, my lord, by the last annexer, I was given 6/6 only that day, that you vacate. So within the whole 1 year, why didn't my lord serve this notice to me?
No, but once the land is acquired.
No, I'm not disputing that.
Then you
Acquisition
vacate it.
Acquisition is
You vacate and go.
That's what the petition is all about, my lord. Paying for time under the circumstances, my lord.
Right.
There is some public interest also, my lord. The locals are, the customers are there. Lordship observed the other day. So we are shifting it within 2 ways. And moreover, my lord, actual construction is yet to start. Now it is cleaning up the, my lord, both sides of the land. That is the process going on. In practice, my lord, tender has to be floated, then construction will have to be started, my lord. It is rainy season. I don't know when, irrespective of when they start.
Show us that there is some right available to you, which entitles you to a protection from this court.
My lord, I believe the under the Land Acquisition and Requisition Act.
Yes.
Section 9, I thought that today. Occupant or any interested person has to be notified. So this is the first notice I have. It's not clear under which act they are doing. But this Assam Mala programs are normally, some other cases, Hoiburgaon I have
This is
seen.
under the new act.
This is the act.
No, is it under the old act or new act?
My lord, it should be under the Land Acquisition and Acquisition Act. New act.
New act, 2013 act. Yes.
So basically, we are not assailing them. But if they talk about giving notice, now why they waited for my lord till 6th of this month to serve this notice? Vacation.
Act 2013.
I will be cancelled. It is section 9.
Are you paying rent to the landowner?
My lord?
Are you paying rent to the landowner?
Definitely.
You are?
Yes. No. Till we sit, my lord, the landlady will do.
Yes, under this act, which provision?
My lord, can I have this book for a moment?
Oh, yeah.
Sorry, I have to inside.
My lord, I have.
Yes.
There is another act, my lord. Acquisition and Requisition Act, my lord. Northeast Act, Acquisition and Acquisition Act. We have.
This acquisition was made under which act?
Old Act maybe.
Under which act?
Because I am.
The comments given in by the deputy commissioner, kindly see. Just at the last portion of paragraph 5.
2013.
13 Act.
2013 Act.
7 also.
Yeah. 2013.
Para 7. Yes, 2013.
Yes, Section 4, my lord, the Old Act.
No, it's under the new act. Why are you referring the old act?
Because it's not clear from their letters, my lord, under.
From their comments, it is clear. It is under the new act.
If their notices are under that act.
That is what they are saying.
Then. Because here I am, my lord, only at Tinen. I didn't know under which act the provision was initiated. And in any case, my lord, I am not challenging the land acquisition process undertaken by them. Basically, my case is that. The day one I said, my lord, the predicament that yes, we are prepared. If this notice perhaps came very late, had it been, my lord, earlier, my lord, we would have been more prompter enough, my lord. Only 6th of June it was given. And after this we started. And lordship, my lord, by your lordship last order, they are hell bent to, my lord, bulldoze, as if, my lord, they were permitted to see the premise. We invited them, they didn't go, my lord. It was now at the stage of, my lord, making the sales for the lockers, my lord.
Yes.
Other things, my lord, it is very easy to see. Everything. The furniture and all these things, my lord, the computers. It is very easy to see everything. The day one, my lord, I told you, lordship, my lord. The only problem is to take care of the lockers. And there are protocols on the Reserve Bank. There will have to be the lockers. Same number, same position. The owners are there, my lord.
The notification was made in the official gazette, must have been published in the newspaper also.
I don't know, my lord. For them to show, my lord.
Moment it is published.
So far as, my lord, I am concerned, I only know about the notice dated, my lord, 6/6/2024, which was straightway given to me.
No, your ignorance about the notice will not make
No.
the notice illegal.
Okay, no, that I cannot. What I am saying that if any publication, government will be able to show, my lord. It is their publication.
That's right.
Not within my knowledge. Ignorance will not be. So it is not a case, my lord, where I am opposing the land acquisition. That is also in some interest, public interest, my lord, definitely. And I am being a, my lord, tenant sandwiched in between, my lord, and I only one time that I could, because some public interest is also there in the customers of the bank, my lord. There are 10 I have stated, my lord. The detailed, also may go to para 10 of my petition, my lord. I have given the detail.
Under what provision is the notice issued?
But the exercise has been done, my lord, under a specific scheme called Assam Mala, whereby, my lord, the part and parcels of land, my lord, it is basically taken down by the authorities of PWD for, my lord, constructions of road. Here is a case, my lord, where lordship will kindly see and appreciate, my lord, from the instructions given to this honorable court, my lord, that the portion of land which is now sought to be.
Tell us the whole process because your readings are not complete.
No, it has been done under the Assam Mala
Where
project.
is that Assam Mala scheme or act or whatever it
It is a specific project. Now, my lord, my respectful submission.
No, under the specific project, are you authorized to buy land?
Yes, authorized to acquire. Now, my lord,
Be that
my lord, with all respect, my lord, I am submitting, my lord, this is not the list. This is not the list before this one. They are only, my lord, it is a mercy petition. They are only,
No,
they are
that's
only,
right.
my lord,
We have to first satisfy ourselves
my lord.
whether they have any right as claimed or as prayed for in the writ petition. If not, we are discussing it.
Yes.
So
Now,
you show us from the petition
yes.
of that scheme or act or whatever you have.
Now, my lord, yes, my lord, under the scheme, my lord, the provisions of 2013 Act is applied. If lordship is taking up that parawise comments, lordship will kindly see, my lord. Kindly see, my lord, at paragraph, my lord, it is there at paragraph number 5, my lord. Kindly see, my lord, the instructions pertaining to paragraph, my lord, I am reading it, my lord, with lordship's kind indulgence, my lord. As per the report, my lord, paragraph number 5, my lord, I am reading. As per the report of the Circle Officer, Sonari Revenue Circle, a letter was received from HDFC Bank authorities dated 30/3/23, wherein they had paid for an additional period of at least 1 year and to compensate an amount of so and so. However, it may be clearly noted that the land in question, which has been acquired under the Assam Mala project for improvement and upgradation of Nahor Ali from Sonari town to so and so, is owned by the landowner Srimati Ahmedi Begum, who is a private respondent out here, my lord, in the writ petition. Covered by Dag number 20, where the building of Damas complex is situated. Now, in Damas complex, my lord, the HDFC Bank, that is the petitioner, is operating. Hence, even though a notice was issued by the Office of the Circle Officer, Sonari Revenue Circle, by letter so and so, the said notice was rectified by another so and so, and my lord, stating that the bank is only a tenant in Damas complex, so they cannot be compensated. In this regard, it may be mentioned that as per the right to fair compensation and transparent 2013 Act, clause 3C, the following points may be considered. Now, my lord, the definition of affected family has been deduced here. Lordship may kindly take up that, my lord, 2013 Act.
That is only for resettlement.
Resettlement.
My lord, may I suggest one between, let us not be confused about under which act the whole process was initiated. I think it will be, but their initial notice, that will be, there cannot be a, my lord, acquisition process in the name of a project, that Assam Mala project or scheme. There has to be, my lord, initiation under a particular act. So we are not certain under which act. There is an act for acquisition and acquisition, my lord.
No, the acquisition process is also not under challenge.
If we go to the act, we must be sure under which act they started the initial first step. Notice. Second step.
Here, my lord.
Third step, compensation. Under which act? That is my, I don't know. Their first notice will indicate that. That in exercise of powers under so and so act, we hereby give you notice that your land is going to be acquired. If you have any objection, submit it in so and so day. As your lordship knows, in all acquisition and requisition. So under which particular act actually they are doing it, it is for the government to show the first notice, it will reflect, or the second notice. Acquisition is not done within a fortnight, my lord. It is phase wise. First the notice goes, objection invited, then public notice is given.
I will have to read the whole, my lord, instructions, my lord. In this regard, it may be mentioned that the right to fair compensation and transparency 2030, the following points may be noted. Affected family. Now, affected family is defined, my lord, under section 3, my lord, subsection C. Lordship may kindly take that, my lord. Affected family. Now, who is the affected family?
They are not claiming to be an affected family. Why are you referring there?
No, therefore, my lord. So, therefore, my lord, their petition
This
is only.
affected family is for resettlement. This is not a question of this act is not only for resettlement or rehabilitation.
Lordship is
Firstly,
absolutely
your
correct.
process for acquisition.
Yeah.
You see, earlier the act was confined only to acquisition. Now it is not only acquisition, it is for rehabilitation, resettlement. They are not claiming for that.
They are not claiming. So therefore, my lord, let us not go. Let us not.
No, kindly come to pay, section 21, notice to interested person.
Section 21
of the act.
Notice to persons interested. The collector shall publish the public notice on his website and cause public notice to be given at convenient places. Now, all this has been done. Person interested will be the owner, landowner, my lord. Now landowner has nothing to, he has already received the compensation. Landowner has already received it. And if anything, if they are agreed, it is to be settled in terms of the lease deed, because there is a standing lease deed between them, between the
No,
petitioner.
they are occupants of a particular building.
Absolutely.
If you have issued a notice,
Yes.
then a copy of the notice will have to be issued on the tenant.
No, copy of the notice will be issued only to the landowner. This is what our instruction says.
Your instructions are, I do not know on what they are based on, but the procedure laid down by law, provision of law will have to be followed. See, what we are asking you,
Yes.
it is the claim of the department that the land has already been acquired.
Yes.
Now, who has acquired?
It has been acquired by the PWD.
By the PWD.
Yes.
Now, if it is by the PWD, for what purposes?
For purpose of
Or,
widening,
where is the scheme? What is the process adopted? In order to say that these people have no locus to even file this case,
yes,
you will have to satisfy that the procedure prescribed under the law has been complied with.
No, therefore, my lord, in my respectful submission, my lord, we need not delve into, because that is not the list. That is not the allegation forthcoming from the petitioner. They are only,
But their prayer is to seek the protection from
protection. They are only seeking time, my lord, in respect of the representation. That is what.
right.
Yes, Lordship may kindly see, my lord. Lordship may kindly say, my lord. I'm traveling, my lord, with all these pages. Page 15 of the petition. Kindly say, my lord. We could have perceived the situation where this acquisition process has been challenged. Page number 15 of the petition, my lord. Page 15.
We know what is there. We have gone through the pleading.
My lord.
We were inclined to grant them some time. It is only on the objection by the government that no, it cannot be granted, that we are taking up the matter for hearing. So therefore, you satisfy the court that the process has been established and there is no locus, so that we can throw out this petition.
Yes. Now, therefore, my lord, Lordship will kindly say, their specific prayer is, my lord, to consider directing the respondents to consider the representation dated 25/4/2024 of the petitioner, and
That's
further that direct, my lord, the respondent authority to grant 5 months time to vacate the said premises. My lord, that representation is already on record, a part of the writ petition. Prior to that, my lord, they had already submitted one requisition, my lord, representation. They had every knowledge about this process, my
That's
lord.
what we want to hear from you. Your mere submission will not do. You have to complete the pleading. Show us from the records at least that the process has been completed.
Process has been completed, my lord. That instruction is
That
already
instruction
there, my
is
lord.
not sufficient for the court to accept that the process has been completed.
Now, Lordship,
On kindly see, kindly read your paragraph number 5.
yes, my lord.
Then they had been informed, letter was received from the bank wherein they paid for additional 1 year and
Yes.
to compensate an amount of rupees so and so.
No, my lord, that was wrongly, at one point of time, a notice was wrongly issued by the cycle officer that you will be entered. Later on, my lord, that notice was withdrawn. In fact, that is not their case also. They also know, my lord, the petitioners are well aware of the fact that, my lord, they have no right to claim compensation.
So why this notice?
Notice has not been challenged. Notice has not been challenged. I need not reverse. I need not reverse, my lord, their allegations. What is not under challenge, my lord, why should I reverse, my lord?
Why this notice of 6 June? You can.
Now, Lordship may kindly come to, my lord, page 47 of the writ petition, my lord, with all respect, my lord. Kindly see, my lord. They had every knowledge last year,
Now,
1
what
year
has
before.
happened to this representation?
Yes, representation. Kindly see what is there, my lord, prayer in the representation.
Where is that? Page number?
Yeah, page number 47.
47.
47. Kindly see, my lord. Kindly see. My lord, this is, my lord, from the bank, from the
No,
petitioner.
not this. 25/4. Where is that 25?
25 is the letter representation. Prior to that, they had filed another representation. That is at page 47. Kindly see what was their prayer. Kindly see, madam. But they cannot resile. They cannot resile from their earlier representation.
What is their prayer?
Their prayer is, my lord, allow us to continue our operation for an additional period of at least 1 year.
Yeah.
Kindly see one page number 47. Page number 47, my lord. Page number 47. My lord, 2, 3, 4. My lord, the last but above paragraph. In the light of the above requesting, Lordship got it, my lord. Page number 47.
Yeah.
Yeah, okay.
What has happened to this representation?
No, my lord, in the light of the above, requesting your good self on 2 points. Firstly, to allow us to continue our operation for an additional period of at least 1 year from the existing premises post issuing of vacation notice so that we can shift to a suitable premises stipulated time frame. Secondly, aims to compensate the amount as per the present written down value of so and so directly to the bank for vacating so and so. So they had undertaken to vacate the premises within 1 year with effect from 30 March 2023. Now 30 March 2024 is already over.
No, what reply have you given to this?
Reply, my lord, we had not. We had not given. We had not given any reply. And after that, they had 1 year time, my lord. And thereafter, my lord, this
We are asking you whether any reply was given or not.
from the Paravise comments, my lord, no reply.
Right. Then they filed a second representation.
Second representation, my lord.
25-4.
Yes, my lord.
What is the status of this representation?
That representation, my lord, perhaps, my lord, in the Paravise comments, it is not there, my lord. And prior to that, Lordship may kindly come to page 53, my lord. Page 53 of the petition, my lord. Kindly stay, my lord. 22/4/2024.
Going by your submissions, their limited prayer is for a disposal of the representation.
Disposal of the
And your representation has not been disposed of as per the Paravise comment. So we direct you to dispose it of.
Dispose of the representation, my lord, and they will also, my lord, vacate it, my lord, because it is for larger public interest, because there is a water logging, lord. You will kindly see, my lord. It is not their case also, my lord, that they are, my lord, preventing it, my lord. They are causing any hindrance to the public. Their prayer is very simple and specific, my lord. They want kindly see here, my lord, authority to grant 5 months time. This 5 months time, my lord, lordship can take a, my lord, judicial decision, my lord, with all respect, my lord. Not 5 months, my lord, lower than that, my lord.
You tell us.
Let it be, my lord, 30 days or 45 days, my lord, because now my lord, the rainy season is coming, my lord. The whole work has been stopped. That is the difficulty. Kindly, my lord, consider.
Which is why we granted the respondents to obtain the time and tell us what is there.
Now that, my lord, we have received the Paravise comments, my lord, we can file an affidavit, but lordship has already taken note of what is there, my lord, in the instructions, my lord, and considering the prayer of the petitioner. My lord, I
These
appreciate
instructions
the,
are
my
made
lord,
for
the
you.
submissions
You have
for
placed this
coming.
instruction before the court. We have not asked for
Sir,
instruction.
I understand, but sometimes it becomes, my lord, difficult on our part also. We are in a hurry, my lord. I also appreciate, my lord, what coming from, my lord.
Yes, Mr. Nag, what do you have to say?
We have expressed our urgency, Malad. At the same time, your lordship, Malad, gives Malad, the petitioner lordship has Malad expressed that 2 months time may be given. Court wants to give them. Malad, we are expressing urgency that the work is very urgent. Lordship, kindly give 30 days time, Malad, within 30 days, lordship will pick the.
Which is why we give you liberty to go and examine their premises, so that whether it is in 30 days or 2 weeks time, they can be transferred.
Malad, it is for.
If you had given a report to the court saying that not even 30 days, in 2 weeks time, premises be ready, we have directed them to move out of the premises.
Malad, since Malad, they are insisting on 5 months time, Malad. Lordship will fix a date, Malad, by which they will get it.
Yes, Mr. Borbora, anything more to be submitted?
2 months we are going to shift. Otherwise, it will be on at our peril. What more I can undertake?
Borbora, Learned Study,
I
said by Mr. M. Smith,
With all humility.
Mr. D. Nath, Senior Government Advocate, appearing for the respondent. Number 2 and 3.
2 and 3.
Mr. R. Porpudari for respondent 1, Mr. P. Gogoi for respondent 4. Anyone for respondent 5?
Fine, we will try that as well, and perhaps.
Have you filed any affidavit?
Have we filed on my lord 12?
You have filed an affidavit?
Yes.
Although notices were not issued.
Then
Advance copy was sought to be served on by way of custody. An affidavit has been filed by the stating that the respondent is refused to accept the notice. Whereas the writ petitioner is a private bank operating in the territory of to the respondent number 5. the because of works, public works relating to construction of drain and road, the land on which the premises is situated, occupied, was acquisition by the state and handed over to the PWD, and adequate compensation was released to the private respondent of five. Pursuant thereto, the PWD department has initiated the process of construction of the drain as well as the road under the what Assam Mala
Yes,
Assam Mala scheme or project.
Assam Mala scheme.
Extension and widening of road.
Which relates to strengthening and widening
Yes.
of the roads. So, the petitioners were tenants initially bring for a period of 1 year by filing an application for the circle officer seeking an extension of time for 1 year. So the representation was dated 30th of March. Subsequently, the petitioner have filed a representation dated 25th of April 2024. Your representation is not complete. Mr. Smith, your representation is complete. 25-4.
25-4 extension at page 54.
54 it begins. Where does it end?
It ends at, my lord. Page 58.
58.
Yes.
So there is no 58 in this book.
58 is also not available with us also.
58 is not enclosed yet.
Second, sorry. Looking at it.
Second copy doesn't.
Is it?
By the said,
I'm sorry. Muy atrás.
it's by the said representation. It is the notice issued by the notary circle officer for vacating the premises, which although was issued to the landlord, may be responsible by. Subsequently, the petitioner will serve the due is dated 6/6/2024, directing the respondents to vacate the premises the earliest as the same is required for demolition permit. Since the representation were not redressed, the grievances were not redressed. Dispose of the representation dated 25 April 2024 and grant further time. So how much time you want?
My
5
lord,
months.
what I said, my lord, I said, not any, 1 day more, 2 months. I will not say now 2.5 months. I cannot.
In your prayer, you said 5 months. 5 months time to get the state representative. 5 months time to vacate the state representative. So, the learned counsel, senior counsel, the private
Gold loans, my lord, gold loan, there are gold sold.
These properties have to be safely transferred to the new location, which the bank has already acquired and safe under renovation, make it appropriate for the purposes of the bank. I ordered it 30, I ordered it 24. The respondents were submitted to complete and the PWD department was directed to complete the subsequently the interim order was extended again. The Internet Council with its response submits that there is an urgent need to carry out the work as the work is in public interest and has a time frame within which the work is executed. Failure to do so will lead to cost escalation. The Barbara, on the other hand, submits that some further time be granted, sufficient time be granted to enable the respondents to shift their the operations of the bank
To the alternate premise.
enabling the petitioners to shift the operations of the bank to newly identified alternative location. So, considering the submission made in the writ petition, including the instructions that received by the council, board is supported of the view that without going into the particulars of the process for acquisition and issuance of notices to the persons interested, including the tenant, which Elbit is also known as the tenant. This court proposes to dispose of the writ petition directly to the petitioner, vacate the premises by shifting their offices, shifting the bank to the new alternative location as expeditiously as possible. Within a period of
2 months.
Come down a little bit.
Lordship.
You can
No,
wait a little.
I'll be happy if your lordship extends it by 10 days, but I will not
Make it
pay.
45 days.
2 months by 45. Sorry, my lord. 2 months it will be. 30th August, my junior says, but we'll shift our interest is to shift it as soon as possible. Our interest is to shift it as soon as possible. Let them
We'll
bulldoze.
vacate the premises and hand over the possession to the respondents positively by 27th of August.
27th of August.
We are giving you little more than 2 more days.
31st.
Then 2 months.
31st.
Not 31st. 27th. 27th August.
31st.
No, not 31st. 27th August.
Lord, just. They will have to see. We will have to see. It is our interest.
Till the premises, till the period, till the date fixed by this court, it is 27th of August. The PWD authorities, the state authorities, including the PWD authorities, will not proceed to demolish or make the building unsafe for occupation anyway. So the petitioners will positively hand over the premises and vacate and hand over the premises by latest by 27th of August 2024. So failure to do so will
invite consequences.
Any failure to do so will not further restrict the respondents in carrying out the construction processes, including taking up steps for demolition of the building. This petition accordingly disposed of in terms of the
I'm so obliged. my lord. If prior to 27th, my lord, if they, my lord.
Oh, we will not stay there for anything.
No, my lord, that is not my submission. My submission is that, my lord, if at a prior date, my lord, day 6, my lord, then we will, in May, my lord.
But they have not stated, so they are getting a rent-free accommodation.
In March, from March 2024, at least.
No, our
There-
lease
there is no
agreement is
landlord.
for 15 years, I think 2030.
So what, are you paying rent?
Yes, my lord.
Who?
Landlady.
No.
She's no longer a landlady.
No. We have been, there was a mechanism, because it is mentioned here, my lord, no point going into that. Our lease was from 2020, March, for 15 years.
As per the instruction, we have already sent a notice to the landlord that will be vacating.
Obliged, Lord.
I'm obliged.